Good morning. Good morning. Good morning. Or afternoon. If you're over across the pond or down under, wherever you are watching us, we are so excited to bring you our continuing coverage of the Commonwealth versus Karen Reed. So today, Allie's joining. She's running a little late. She'll be here. We will be hanging. Today is motions. So this is what they call a final pretrial date, scheduled for 2 days. This is the absolute final push towards trial. So as you guys all know, we still have the motion to dismiss ruling that is out there hanging in the ether, waiting to find out whether or not she's going to grant it. Like I've told you guys, I mean, you file motions like that where you understand what the end game could be is that the trial goes away. But you cannot make any kind of assumptions as an attorney. You have to continue to plow forward. You have to continue to prepare as if it's not going to be granted, and you prepare for trial, which is exactly what they're doing. And we all know she's not going to grant it. I mean, I think if she had any inkling that she was going to grant it, she'd be saving herself the time by not having these 2 days of hearing. She would have been more feverishly working on a ruling, because she's going to make findings, unlike our judge over in Delphi, Judge Gull. At least Canoni makes findings, so that's one thing. So today should be, and it's hard to know how long these are going to go. Like a lot of these are kind of quick hitters, even though it's scheduled for 2 days. I mean, in terms of, there's going to be argument on some of them. Some of them, the argument will be very brief, and some of it will be a little more lengthy. I anticipate we will get a lot of Bobby Alessi today, which is always exciting for me. I don't know about y'all, but love hearing him just yap. It's the best. It's like you have these diametric opposites. You have one lawyer you love to hear yap, and the other one that you can't stand to hear yap. So you have like polar opposites. So that's, but I think we're going to get a lot of Bobby today, and not Bobby Mata, the other Bobby, that Bobby. So, all right. As per usual, it's going to be the battle with the sound. I think I'm going to try, and all you guys in chat, which would be very helpful. Like, I tend to lean towards Boston 25 just because I think that their sound is usually better, but sometimes it's Court TV, or Boston 10 is sometimes better. It's kind of one of those things where, we're going to have to kind of pick and figure it out. All right. They've got so I'm going to put it up because we're getting close. So I'm going with Boston 10. That's what's happening right now. Let's see. Okay. All right. Okay. All right. We got OnlyFan. That thing's going. All right. Oh, there's Allie hates the circles. Hates the circles. All right. There you go. I think the circles do make it bigger, though. So, I just swap sides. I'm so confused by our little setup back here sometimes. Yeah, I'm usually in pretty good spirits, high in the morning, early, sleepy Bob. Now I'm like well rested, Bob. I went to bed pretty early last night. Allie and I are watching something that is a high recommend, and that is, it's on Netflix. It's called Adolescence. It's a British UK show. It's phenomenal. I love everything that comes over. Like in the kind of in the crime, true crime stuff. Like I've got BritBox. I watch a lot of their stuff, but their series are phenomenal. The acting and writing is always great. Plus, I just kind of love that vibe of checking out a different criminal justice system. But that show, like the first episode was so like it just immediately drew me in because it was so authentic. It felt so real in terms of it. And like I'm not gonna give any spoilers, but basically you've got the thing opens up with a family's home getting raided by the cops, and they're in shock as they come in the house, and then they end up arresting the 13-year-old son under suspicion of murder. And then the first whole episode is how they process him in. It is exactly it is so spot on in terms of everything about how horrifying it would be to be the parents in that situation, the kid, all the while you're sitting there, like you're, oh my God, like, what's the crime? What's the crime? It's just so well done. I highly, highly recommend it. I think I fell asleep. We were just starting episode 4. So there's Turtle Boy. There's Aiden. It's in there. His perch. He's getting in there for maybe his last time he's going to be allowed in there. We'll see. Yeah, this is gonna be great. Like I can imagine the snark level today. It's gonna be next level. It's gonna be next level. It's going to be. I mean, you could just tell by the filings. Like when lawyers are firing on each other like that, Creed, that makes me very happy. The Bobbies, they're far more polite than American cops. But I find that as a people, the English are far more polite than Americans. Sorry, Americans. It's just true. We were there last year. It's Karen.
Yeah, I'm coming.
All right, it's about time, lady pants. Karen looking dapper. Not afraid to talk to Aiden. I like it. So there you go. You know. There you go. That kind of felt like when I was going to all the trial dates in Delphi, and the murder queefs were saying I was a paid shill for the defense, but like I'm like, I don't care about these people or what they say. Obviously, I'm not a paid shill. And I was like, but I would talk to the defense during breaks and stuff like that. I'm like, these are my friends. Yes, exactly, BB. Exactly. All right, we got our sound. So I'm gonna boost. I'm hoping I don't have to boost, but if I do, we will turn our mics now. We'll crank them down so as not to blow your eardrums out. We got the usual suspects in there in the court. They're dialing in.
Welcome to Zoom for Government.
Bobby looks ready.
Enter your meeting ID.
You guys believe he's like 67? Crazy. Yeah, maybe if we get lucky, maybe that'll happen during lunch, and yeah, we'll pop over for the arraignment.
You have joined the meeting as an attendee and will be muted throughout the meeting.
And I'm talking about over at Aiden's thing.
The host would like you to unmute. You are unmuted.
So for you guys right now, how does the Zoom call sound, and how does like the courtroom chatter? Can you guys hear it? Oh, I thought he was 23. It's a spring chicken. Would you see Lally fire the mic down? Sounds great so far. All right, perfect. Exciting. Who, Brennan? Nah, Brennan's like, I bet you Brennan is early 50s, if I had to take a guess. Brennan's probably around my age, I would guess.
Pass me up. Till we get going, then you can put it
Mr. Reed, what a supportive parent, you know? He's there every single court date, rain or shine. Rain or shine. So, but I do want you guys to watch Adolescence. I think it's worth it. Again, it's on Netflix. Watch it. Oh yeah, I mean, Meg, I hope so.
Hey, I added myself to the stage, but I don't see myself.
Oh, hold on, baby cakes. There she is.
Lady pants, baby cakes. What is going on this morning?
No, that was Lati. L-A-T-E.
Well, if I wasn't so conscious about how I looked, I would have just gotten on. But of course, I had to do some makeup.
Yeah, but you're gorgeous all the time. So, like, that's
So
all
you
in that's
say.
all in your own mind.
So you say.
It's all in your own mind. No, I don't say it. I'm sure the chat is about to agree with me in mass. So, and I am now joined by my beautiful and brilliant co-host, Allie. What's up, girl?
Hey, babe. Hey, all.
So we're up and running. We're getting ready. I was telling the people that we're enjoying. Did you stay up later than I did for?
I fell asleep, so I don't know.
Oh, good. So did I. Did you see the end of 3 though? Okay, so did I.
I mean, I was awake for, I felt like a large part of 1. So, I mean, 4.
That's what I'm asking.
But I didn't watch the whole thing, but I watched part of 4.
Oh, you did? I think I fell asleep pretty quick. As soon as I turn over, it's done.
Yeah.
Done. So it's over.
Done so.
I was feeling it though. I was tired. All right, we got about 261 in. Little reminder. Don't forget to hit that like. Please.
Ask if
Like,
anyone's still hearing an echo but that might have been when I first logged on.
How can we flop us to the other side? Let me see.
I got you.
Oh, there we go. See, that looks better.
Yeah.
Right?
Yeah, especially because
on this side, we're definitely taking up more of the screen, I think.
Right. But so is the I don't know. To me, the picture looks small. I don't know what's happening.
Yeah, I haven't had an echo. I think that was something with me the other day when we had the echo. Like I had an echo with Rich and Josh.
No, but when I first logged in and couldn't see me but could hear me, I heard like an echo for a second. So sometimes it takes, the chat a second for me to see it. So it could have been like that 1 minute.
Yeah, you sound crisp and fantastic to me. And we got a little bit of sound early, so I think we're going to be okay because it's nice to not have to boost. If it's a little low for you guys in terms of the courtroom, just let me know. I'll boost it. My preference is to not boost it, but.
So I tried to make myself taller because I was watching, it's always freaks me out when Bob Singer has our lives up on the television. I can really see us. I'm like, oh my God, that's what people see. I like when we're on little boxes on story for another day.
Justice of the Norfolk Superior Court before the county.
All right, I'll be right back.
Give your attendance, you shall be heard.
So hopefully I don't swing. That's my point. So I'm going to try.
117, the Commonwealth versus Karen Reed. Can a counsel identify themselves, starting with the Commonwealth?
Good morning, Your Honor. Laura McLaughlin. Good morning, Ms. McLaughlin.
Morning, Your Honor.
It's quiet.
Good morning, Mr. Lally.
Good morning, Your Honor. Hank Brennan for the Commonwealth.
Good morning, Mr. Brennan.
Good morning, Your Honor. Alan Jackson from the street.
Good morning, Mr. Jackson.
Good morning, Your Honor. Elizabeth Little, also on behalf of Ms. Reed.
Good morning, Ms. Little.
Morning, Your Honor. Robert Alessi on behalf of Ms. Reed.
It's a little soft.
It's a little soft.
I don't know. Ask the
Good morning,
people.
Ms. Giannetti. All right, so we have a lot to cover, but what I'm going to start with is a decision on the Commonwealth's motion to exclude employees of ARCA.
Turn my sound.
So I think I told counsel
I just turned my volume up. I
before
think it's good.
that I had reviewed. So first we had full hearing from counsel. I heard from the lawyers. I heard from Mr. Alessi on behalf of the lawyers. I've read the transcripts. I've listened to the sidebar conference and read that transcript. And I've certainly read the pleadings. So based on all the evidence, I conclude that there has not been the candor required of all lawyers has not been demonstrated here.
Okay.
I find that there have been repeated misrepresentations made to the court by defense counsel, and I conclude that they were deliberate. Regarding the relationship with the ARCA witnesses.
Oh my God.
They were made at sidebar, in open court, and in pleadings. And I think the record is pretty clear, and I find that on July 25th, 2024, payment was made to the ARCA witnesses. Yet on February 26, 2025, in a pleading written by Ms. Little, signed by all three defense counsel, says the Commonwealth's motion to exclude these exculpatory expert witnesses, ARCA witnesses, who were not hired or paid for by the defense, is not made in good faith and is a desperate and transparent attempt to keep exculpatory testimony of neutral expert witnesses from reaching the jury in this case. The next page. Ironically, the Commonwealth accuses the defendant of failing to comply with her discovery obligations while conceding that the information is not in her care, custody, or control. Moreover, here, the defense has gone above and beyond its reciprocal discovery obligations and has already satisfied all of its mandatory discovery obligations under Rule 14 and turned over all additional information in the control and custody of the defense relating to the ARCA witnesses as ordered by the court.
February 17th.
So I find or conclude that that was a material misrepresentation and that it was deliberate. So I find that there is a flagrant violation of the Rule 14 obligations. And before I decide which sanctions are appropriate, I need to see defense counsel and Ms. Reed at sidebar. I'm going to ask that the Commonwealth
And Ms.
where
Reed.
they are. I'm going to seal this sidebar, but I need to have a colloquy with Ms. Reed.
Oh
before
my
I figure out
God.
exactly what I'm going to do here. So
Wow.
Holy shit. All right. So the only reason to be doing that is if she is obviously going to be saying that you're
Removing one of her
losing some of
lawyers.
your lawyers.
Wow. Wow.
This is what? So no further hearing.
Wow. I'm stunned.
Oh my God.
I am stunned. I'm sitting here stunned right now.
Okay, turn us down so people can turn the volume up.
Okay. Or
Just for now, let's do that.
Maybe I should check Court TV.
Go ahead. For now, I put me down to 39.
Okay. Holy shit.
Babe, don't take it off until you decide something else. Just stick it
No,
back
I'm
up.
gonna I need for these guys to hear it.
All right, well, hurry up.
I am. They're at sidebar. This is gonna take a minute.
Maybe not.
Honey.
Is this live? No.
So here. Oh wait.
Wait, go back one more.
Decide which sanctions are appropriate. I need to see defense counsel and Ms. Reed.
Sounds the same, but just leave it. Go live.
Remain where they are. I'm going to seal this sidebar, but I need to have a
Go
call.
live.
Ms. Reed.
Okay.
Thank you. Jeez. Shoo.
Honey, this she's telling him it sounds like she's gonna boot one of the lawyers. This isn't gonna be a 2-second conversation.
Well, but the colloquy is just like, just stay live.
I was live. I was making sure.
Oh my God. What I don't get, and I'm 99.9% sure that I'm accurate, is before January 25th, 2025, they had turned over the proof of payment. So I don't know why she's acting like that. That's what they meant. That's just their way, their narrative, the way they say it. It's that their opinion was not
This is
paid
that
for.
bias. This is bias, you know? I mean, this
Oh
is
God,
what
I
everybody's
really thought I just had like this hope that she was gonna be more even keeled about this. Guys, tell us how the sound is. I turned my volume down to 39. I don't know if Bob turned his down, but make
I
sure
did not. Am I loud, y'all? Because I haven't boosted it.
I know, but even if you don't boost it, if you turn us down, it allows them to turn the volume up.
Okay. I might still be down a little bit.
All right. Well, I'm at 39.
Okay. Yeah, I'm still at 57. Like I never put it on automatic again. So I should be good.
Okay. All right.
Okay.
Now Bob is loud. Go down a little bit for you. Yeah.
I'm still a little loud. Okay.
Go down to like 39.
All right. Shh.
Sound is fine. I don't know. No, but you can guarantee they're not going to trial. And
Shh.
all right, they're back. Fuck.
All right. So there's no greater constitutional right than the defendant's right to a fair trial, including a fair and impartial jury, the right to present a defense and confront witnesses, and the right to counsel, which includes counsel of her choice. So I've just had a thorough colloquy with Ms. Reed. I believe it was extensive and thorough, and she has expressed to me
She wants her
a
lawyers.
strong desire to continue with her lawyers. Ms. Giannetti, is Mr. Jackson lead counsel? I just want to make the record clear.
Wow.
Mr. Jackson, are you lead counsel?
We don't define our roles in such a manner, Your Honor.
Okay, so because Mr. Giannetti is not pro hoc vice counsel, and Mr. Giannetti can try this case if need be by himself. All right. But Ms. Reed does have a strong desire to keep all of her lawyers, notwithstanding the Rule 14 violation and the apparent lack of candor, the findings and rulings I've made. So based on that,
There you go.
I am not going to revoke pro hoc vice licenses. I don't expect to have to address this again. Candor with the court is essential. It's the bedrock obligation of all lawyers who appear in this court and all courts in Massachusetts. A lawyer is only as good as his or her word, and I need to be able to take counsel at their word. So I'm not going to tolerate false statements, any stretching of the truth, no misleading distortions. There's no place for that in the courtroom. And Mr. Jackson, you stated
Brennan?
this very eloquently in your closing argument last time. So, Commonwealth, I am denying your motion
Wow.
to exclude the ARCA witnesses. Those witnesses can testify as long as counsel complies with their reciprocal discovery obligations. I will allow a full cross-examination, Mr. Brennan, and I will review any proposed curative instructions, limiting instructions, or final jury instructions. So that's my ruling on that.
Wow.
So we'll move on to Mr. Lessie. You didn't have a chance.
Okay, I'm going to
Pause
pause
it.
it real quickly. All right, so just for you guys out there, like as scary as that seemed, that is what judges do. If they make certain findings, remember what they're trying to do is put the fear of God into those lawyers that are in that courtroom, and that's exactly what she just did.
And
Because
she wanted the she was definitely taking the opportunity to try and remove them, but she did the right thing. That's what needs to get done. The judge makes a firm ruling. She's decided, I'm going to remove your lawyers unless you tell me you absolutely still want them no matter what. And she did, and the judge did. So, although I just think she went a little far in her interpretation, in my opinion. like, yeah, I see where she can interpret some of what he said or they said at different points as being um you know, not 100% accurate, but I just think when you take it in context, the way they explained that they weren't trying that wasn't what they were trying to do. They clearly had already turned over the fact that they had paid the witnesses. Um, and I hope
Yeah,
at some
and
point she turns her face to Brennan because obviously we're all agreeing
exactly.
with all your comments out there. I see you guys all saying it, like why isn't she holding Brennan accountable? Let's just hope right now this was her time to address this issue to the defense, and at some point she's going to turn that face and address that issue. I think then would have been the appropriate time, like from either side. Ba, 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 ba,
Well,
ba.
I think when we get to the proper time for that will be the motion to dismiss. When she denies it, I expect her to turn to Brennan and say the exact same things to him and to Lally, to both of them. She should ask both of them to rise. She should read them the riot act and then do whatever she's going to do with that, which is ultimately deny it. But look, and you guys are not wrong. I see you guys saying it was a PR move. It wasn't a PR move in terms of she's got to make a record. So she's made findings that there were candor issues, that there were misrepresentations. I agree with that. The end effect is that it does hurt the defense. It does hurt Karen Reed and the public's perception, because now all the trolls on the other side of it are going to be talking about how Judge Cannoni just confirmed they're big fat liars. Liar, liar, pants on
Well,
fire. I mean, so that
don't forget that Andrew Jackson went out and said to the
Andrew
press,
Jackson are
Jesus,
oh,
I don't know what's wrong with me.
it's
Alan
very
Jackson,
presidential.
he went out to the press and he said afterwards, and I know it's not in the pleadings and it's whatever, but still an ethical violation, and still said we never paid for their testimony. However, they literally paid for the cost for them to come testify.
All right, let's get going. We wanted to talk about that a bit.
That's last time on the motion to exclude the testimony of Dr. Wolf. So I'll hear you on that.
Thank you, Your Honor.
Jackson's feeling all of that thing, man. Like we've been there. You
Beautiful
feel it.
messy
Like you
balls
can't.
trying to keep my expectations in line with this comment, which it should.
You can tell he's relieved as hell. It's a scary moment in time when
May it
when
please the
you're
court,
on the chopping
Understood,
block.
Mike, but
the proposed testimony supported by the Commonwealth of Dr. Wolf should be stricken in its entirety. The subject matter of Dr. Wolf's purported testimony by his own report and the Commonwealth's own motion is that Dr. Wolf will testify, is proposed to testify as to the cause and the manner of death of the decedent. That is the subject matter of the testimony. And as the court is well aware, in order for Dr. Wolf to be able to make testimony with regard to that subject matter, he has to demonstrate, and the Commonwealth has the burden of proof by a preponderance of the evidence, to demonstrate that he's qualified, prong one, and two, that the methodology is reliable, and specifically either that the methodology is commonly accepted in the relevant medical community, or that the proposed testimony can satisfy the 5 non-exhaustive factors of Daubert-Lanigan. The entire motion, papers, and supporting documentation fail to even allege that the methodology is generally accepted in the scientific community. It's not alleged, let alone demonstrated. In terms of his qualifications, it is essentially Hornbook law that to testify about the manner of death as opposed to causation, this cause of death, you need to be a medical examiner, a forensic pathologist, or both. Conceitedly, Dr. Wolf is not a forensic pathologist and he's not a medical examiner. So I'm going to just put aside for the moment the cause of death. I want to speak specific because he's got to be able to show both, because he's opining about both. So there is no demonstration in the record that is before Your Honor as to how Dr. Wolf is qualified to talk about the manner of death. Dr. Wolf invokes a terminology called mechanism of injury. That's the closest he comes to talking about manner of death. And specifically in his report, which is Exhibit A to our motion, the entirety of his opinion is in that exhibit, NDA 02801. It is a mere 15 lines, one paragraph. And the applicable aspects of that paragraph is he says the following: based on the findings of his autopsy, his being the decedent's, it is clear that the mechanism of injury was a fall backwards, resulting in not only the basilar or skull fracture, but also a subarachnoid hemorrhage and contusions consistent with a coup contra coup mechanism. Mechanism of injury is not at all probative or even relative to cause of death. We're not talking about an injury here. We're talking about the manner of death. And mechanism of injury doesn't satisfy it. But the point first, Your Honor, is he's not qualified because he is a neurologist. His CV makes it very clear he's a neurologist, and his focus of his practice, by his own words, is based upon the precise invocation of radiation to treat incurable cancer. That's what his specialty is. That's what he currently does. So in terms of qualifications to talk about manner of death, he doesn't state the manner word, but he uses mechanism. He doesn't state mechanism of death. He states mechanism of injury, and mechanism of injury is irrelevant. So on qualification prong, Your Honor, it is completely lacking in the record that he is qualified. It's not enough to say you're a neurologist and head of neurology at a certain center. And this is juxtaposed next to the fact that the Commonwealth, the autopsy, which is very clear that those that are qualified, Dr. Stonebridge and Dr. Scorti-Bello. Dr. Stonebridge didn't even venture into the manner of death at all, didn't comment on it. Dr. Scorti-Bello, who is a medical examiner and who is board certified in pathology, she concluded that the manner of death was undetermined. So here you have the juxtaposition of a medical examiner qualified to render opinions in those areas, saying the cause of death is undetermined, and you have an unqualified neurologist not speaking to manner, but speaking to mechanism of injury. So in terms of the paragraph that I was just citing in his findings, it says, based on the findings of his autopsy, it is clear that the mechanism of injury was a fall backwards, resulting not only, et cetera, and then he goes on to say the head injury was clearly inconsistent with any type of mechanism of injury, such as a bat, hammer, or a car hitting him directly. Then what he goes on to further to go beyond his qualifications, he says the frozen ground was enough that when Mr. O'Keefe fell backwards, his injuries were sustained. Where is the support that Mr. O'Keefe fell backwards? A neurologist can't determine That is a manner of death. He provides zero bases, zero, for his conclusion that Mr. O'Keefe fell backwards. Where is that? And it's also not in the autopsy. And with regard to his qualifications to determine whether the ground was frozen, I covered that with regard to Mr. Gilman. You need to be a pedologist. You need to know something about soil. He doesn't even begin to state how he concluded the ground was frozen. He wasn't there on the date of the incident. So there's no basis for that, but that is part of his opinion and methodology. And now to leaving his lack of qualifications, where is the citation to any study, any acceptance of how Dr. Wolf has come to his conclusions? There's nothing there. And this, Your Honor, is become a pattern of the Commonwealth where they put forth witnesses and they don't tether the methodology, if you can discern it, to common acceptance or the Dalbert-Lanigan factors. So in terms of both prongs, Dr. Wolf fails because the Commonwealth has not even begun to meet its burden. I would like to also reference what we just received last night, which is an article that was co-authored by Dr. Wolf. And I want to note and this is fractures of the classification and clinical features. This is 35 years old, and it is notable both for what it doesn't say and what it does say. First, what this article doesn't do is it doesn't talk about how one determines what a mechanism of injury is. So I'm even going to assume for the moment the parlance of Dr. Wolf mechanism of injury. And if Your Honor would look at, please, page 593 of the study. And it's basically a meta study. They went back and looked at a lot of data and information, but it says under results, second paragraph, the mechanisms of injury were similar for all three fracture types. Motor vehicle and motorcycle accidents were the most common mechanisms, accounting for 47%. And then it goes on and it says 3 patients were victims of falls. But what this article stands for is that those were all known mechanisms of injury. It was determined before this study even occurred what the mechanism was. This study is not how does one determine when it's unknown what the mechanism of injury is with regard to a decedent. And that feeds back into the lack of qualifications of Dr. Wolf, because we're not given one example of where Dr. Wolf, before his report, his 1-paragraph report on conclusions, of when he's ever done this before. It's not stated that he's ever taken a decedent and determined the manner of death. And I note that this study talks about mechanisms of injury, which scientifically is completely different from manner of death. And what it appears the Commonwealth is trying to do is to back into manner of death through the parlance of mechanism of injury. And that is not at all probative of manner of death. And lastly, this study only stands for the proposition of mechanism of injury. What they looked at is once the injury occurred, what were the mechanisms that were occurring through the brain? What happened inside of the brain that led to the various injuries? So this study doesn't at all, one, support any methodology, number one. It doesn't stand at all that this is the methodology for how one determines in a decedent what was the cause, because the cause of the injury was already determined going into the study. And it also doesn't state anything about the paragraph that Dr. Wolf has explicated in his report. And I will conclude with 2 points. Dr. Wolf says, based on the findings of his autopsy, it is clear. Well, the autopsy doesn't come to any conclusion on manner of death. The autopsy doesn't speak to mechanism of injury. So it is a non sequitur, Your Honor, to say that based on the findings of his autopsy, and we know from Dalbert Lanigan, you've got to apply your methodology to the facts and evidence in the case. And the only facts and evidence that Dr. Wolf uses, by his own words, is the autopsy, which doesn't support at all what he is stating in his report. The second and last point, Your Honor, is that it is not sufficient in the case law in Massachusetts. It's not sufficient under 702 for someone simply to come in and say, I'm a neurologist, I therefore know the brain, and then take the leap from that foundation into a conclusion with regard to manner of death. So in sum, Your Honor, he's not a medical examiner, he's not a forensic pathologist, he has not stated any experience whatsoever in doing what he's doing here, meaning to determine the manner of death of a decedent. And his methodology is completely unsupported. We only have one article, and I've gone through why that article is insufficient. So we would request, Your Honor, and urge the court to exclude Dr. Wolf from testifying in matters beyond his kin. And in the alternative, we would request an evidentiary hearing, because we and the defendant has a constitutional right to cross-examination. And this is the same with Mr. Gilman. It's the same with other experts where there is no statement of the methodology, as here, there's none, and there's no tethering to a study. And how is it that one can cross-examine a witness that doesn't even begin to approach the two prongs of the Dalbert inquiry?
All right, thank you. Mr. Brennan?
May I?
Please.
Attorney Lessie mistakenly misstates Dr. Wolf's credentials. Dr. Wolf is not a neurologist, he's a neurosurgeon. He's not simply a neurosurgeon, and it's not that he's a renowned neurosurgeon, but he has over 35 years of experience as a neurosurgeon. In addition to his opinion, you can see that Dr. Wolf has an extraordinary history of experience as a neurosurgeon. His CV is attached. In his internships as a neurosurgeon, he engages in an internship in pathology, neuropathology. We can see from his major research interests includes treatment of head injury, spinal cord injury. Dr. Wolf was the leader and director of the Miami Neuroscience Center for 17 years, from 1993 to 2011, the busiest neuroscience center in the country. He has treated tens and thousands of patients with head injuries, surgeries. His professional memberships are too long to list. Page 3 of his resume. His research is broad and precise and specific to head injuries. We can see in his research listed on page 4, he's a principal investigator in THAM treatment of brain tissue, acidosis in severely injured patients, principal investigator, PEG, SOD, and severe head injury. Improving outcomes in severe head injury, PEG, SOD, also principal investigator, IRB protocol, brain pathology. He is well published. His book chapters that he listed anyways, list 16, many of them dealing specifically with head injury and brain injury. Book chapters include head injury and difficult medical management, pediatric neurosurgical emergencies, complication of head injuries in adults, imaging of craniocerebral trauma, imaging and trauma and critical care, emergency room assessment of head injury patients, intracranial injuries. He has numerous journal articles, a slew of them specific to head injuries. Intracranial pressure, number 2 on his journal articles. Initial management of brain and spinal cord injuries, number 9. Number 16, which is the document that I produced to counsel last night, listed in his journal articles, number 16. Fractures of the clivus, classifications and clinical features. His journal articles are numerous, too numerous to go through, but you can see that he is well published, over 70 articles. Presentations specifically on fractures, basal type injuries, number 5 on page 13. Number 9, neurosurgical management of traumatic brain injury. Number 10, acute head injury. And the list goes on. Over 90 references. Lectures and meetings, many of them dealing with head injuries. Over 100 lectures listed for reference, actually over 130, and a number of web publications. So this neurosurgeon who has this extraordinary experience is qualified. The ability to testify about head injuries and medical diagnosis and cause of death is not limited to a pathologist. In fact, I would suggest that the experience of Dr. Wolf is far superior to any pathologist. The difference is a pathologist treats patients that are already dead. Dr. Wolf treats patients that are in trauma, who some survive and many die. So he is intimately familiar, not just with looking at a deceased in a lab, he's intimately familiar with assessing the injuries after they occur, diagnosing what the injury is, and an attempt to save the person's life. And so he's well attuned after tens of thousands of surgeries to understand the causation of a brain injury and what causes
Tens
death.
of thousands?
Looking at Dr. Wolf's report, although short,
No.
it is clear that the injury that was occurred by Mr. O'Keefe was an injury known as counter-coup. And I dare say the defense proposed expert, Dr. LaPosada, is not in disagreement with that. To understand counter-coup, it occurs from a fall backwards on the ground. It can't occur from a bat or a punch or hit. There's not enough force. It occurs when the back of the head hits the ground and then the brain shifts to the front of the head. That is what the autopsy reports show. It may be that the medical examiner for the Commonwealth didn't have the same level of experience and didn't diagnose it, but this expert does have that expertise, and it is no different than the pathologist that's proffered by the defense. The periorbital ecchymosis that is directly related to the basal fracture, the swelling around the eyes, no different than Dr. LaPosada's opinion, exactly the same. One thing he doesn't say is that the body was moved. There was no evidence or information for that. He doesn't extend himself as a detective or put in unplausible theories in his proposed testimony. He is intimately familiar with countercoup, having treated tens of thousands of patients, and he understands in countercoup how it can lead to suffocation at the top of the spinal cord. And so his opinion is clearly supported by his extraordinary experience, his writings, his history. It can't be that his ultimate conclusions of countercoup and ecchymosis, periorbital ecchymosis, is in dispute. It seems that the defense simply prefers the original medical examiner for the Commonwealth. But we expect to call Dr. Wolf, and I would suggest that he's more than qualified.
All right, thank you. Mr. Ellis, anything final?
Yes, thank you, Ron. Thank you, Mr. President. Thank you.
Pause it when he's done.
Your Honor, I'm going to note what Attorney Brennan did not state. He did not address at all how the methodology, to the extent it's discernible of Dr. Wolf, is commonly accepted or it satisfies any of the Daubert factors. And that is the fatal aspect of Dr. Wolf's opinion. It's not stated. You have to have either common acceptance or satisfaction of the 5 non-exhaustive Daubert factors. It wasn't addressed, and I think it's reasonable to conclude that it wasn't addressed because it doesn't exist. That alone dooms Dr. Wolf's opinions. I will stipulate, for purposes of this argument only, the cause of death prong. Let's assume, just for purposes, just to focus on manner of death, let's assume hypothetically that Dr. Wolf is qualified to testify about cause of death. Mr. Brennan did not address at all his qualifications to discuss and opine on manner of death. And that is the distinction I emphasize, Your Honor. Manner of death, he has not stated one qualification on manner of death. So the defense urges the court to draw the distinction, to limit his testimony to cause of death, not manner of death, because we know, and we cited the Graham article, which is attached to our motion, which specifies who is qualified to talk about manner of death. Because what does manner of death do? It takes into account all the circumstances surrounding the crime investigation. That's what medical examiners and forensic pathologists are qualified to do. Attorney Brennan cited that in his CV, there's a reference to an internship in pathology. I looked, I didn't see it, but let's assume that it exists. Let's assume he has an internship
They all do that,
in
don't
pathology.
they do their.
That does not qualify him to engage in manner of death 40 years later without any experience from that internship all the way until 2025. Lastly, Attorney Brennan goes through numerous studies, and I appreciate that he did, because the CV is almost endless with meetings, presentations. There's 4 peer-reviewed articles. That's it. 4 peer-reviewed of Dr. Wolf. None of them address or come close to the topic that he's talking about. My last point is this with regard to Dr. Wolf's qualifications and what his practice has been. And Attorney Brennan concedes it by his own words. He said cause of injury. And again, for purposes of this argument only, I will concede cause of injury. But manner of death was not addressed by Attorney Brennan. It's not addressed in any of the qualifications of Dr. Wolf, and it's not addressed in terms of the one paragraph that we have. And for something as significant as this, one paragraph that doesn't address common acceptance, methodology, Daubert factors, Your Honor, I don't know how a record is even begun to be established for him to be qualified or to opine on manner of death. So we would urge your honor to find that he is not qualified to testify about manner of death, that mechanism of injury cannot be manner of death, and that he be so limited to the extent the court desires and concludes that he has some relevance here. But in terms of all of the record that's presented, including the CV, et cetera, there's not one instance where we see that Dr. Wolf has even approached determining cause of death or manner of death at all. So I don't see where there's a record to find him being able to do that for the first time in charges of this nature. Thank you.
Do you want to respond at all, Mr. Brennan?
Well, she really lets him go back, forth, back, forth.
Yeah, it's weird.
At some point, arguments become semantical and theoretical, but not practical. This doctor has treated thousands and thousands of patients, many,
We mean
unfortunately,
to
which
say
have
is something
died.
different.
And as a neurosurgeon, engaging in the operations in the study of the brain and the patients, it is obvious that the neurosurgeon would understand and appreciate why his patients are dying, because that is part of the study of trying to save them. So for him to reduce on a piece of paper that the manner of death is based on my thousands and thousands of patients and my years and decades of experience, seeing firsthand many of these patients I cared for or tried to help died, and this is why. Technically, he could do that if that satisfied Mr. Alisi, but that is so unnecessary because it's obvious. Thank you.
Okay. Thank you. All right, so we have a series of motions in limine. I'm going to start with,
So, like something about the methodology here is not clicking with me because it's kind of like the same argument. He's a doctor and he's opining about a medical condition, so I'm not sure what methodology that they are looking for exactly in that sense. And I think that he's, when he argues there's no evidence that he fell back and hit his head, I mean, that's the same argument that the state could make. Well, but he wasn't bit by a dog. He was scratched by a tail light, so I think that he should be limited in some way, but in the same sense, I think that, a lot of that's probably going nowhere.
Yeah, and I mean he's definitely getting in. And so we all kind of got lost in the heat of the moment there with the first thing that she was addressing, which was obviously the motion to limit and or bar the ARCA experts. They're obviously in. I just, in case you guys missed that, because everyone was not breathing for a second when we thought Alan Jackson was going to get bounced. So ARCA's in. I anticipate that every single witness is going to come in. She may, however, limit what they're allowed to testify to in terms of opinion. That I think there's going to be limiting instructions, but she's not going to bar any of the witnesses from coming in. I don't think on either side when it comes to experts. So, and the other thing that I just want to point out that even though she didn't specifically name Alan Jackson during her colloquy there or her admonishment during her findings, it was clearly relating to Alan Jackson. And you could see Alan sitting at the council table today, knowing that those findings that she's made on the record are going to impact him after this trial.
I was going to
just
say
understand that. Like those findings of lack of candor with the court and misrepresentations to the court are like that's a big blow to him in terms of him having to deal with disciplinary committees after the fact. So like you can see he's upset.
They're
Like, I mean,
probably all upset because she said they all signed it. So this affects
right.
all of them. And especially, I was going to mention this when you, and I got to leave in a minute, but when you apply pro hoc vici in other states, that's one of the questions that they're asked. Now, they're going to have to walk a fine line because the question is usually, have you ever been sanctioned by a court for? So they're going to have the same little, how do I
Issue.
play on these words here? Did
Right.
I pay this witness or did I pay for his opinion? You know, she would have sanctioned them, but didn't because of that. But there was a finding of a lack of candor of court. And yes, that's going to follow all of them. She very well could file something with uh her state and their local state's bar, like Bob's saying, to the disciplinary commission. And other than that, every time any one of them goes to apply pro hoc vici, that's an issue.
Right. Because that, like
She'll
Allie
be
was
back.
saying, that's one of the questions that they'll ask on the application when you're filing your application to be admitted pro hoc is, do you have, and that's what Allie's trying to say. Like, they're going to have to kind of, that word, have you been sanctioned? Because ultimately he wasn't. There was no sanction put in place. She didn't revoke his license. She didn't make him pay a fine, which is what I thought. If she found that there was going to be a lack of candor, that would have been her remedy, because nothing was going to outrank Karen Reed's Sixth Amendment right to counsel. Like, and she made that clear. That was the entire point of the sidebar. I saw somebody ask, well, what did she ask Karen at sidebar? She answered it when she took the bench. She said, I spoke to Miss Reed in light of my findings that her counsel lacked candor and that they misrepresented some facts to the court. Do you still want them to remain as your counsel? And of course, Karen said 100%. So, and once she said that like Canoni knew that there was no way that she could bounce it, because that's automatic redo on this trial. It would have been structural error for her to remove Karen Reed's counsel of choice. So now the question becomes, when she inevitably denies.
I was going to poke in to say it could have been structural error, but I think the more of the issue is because she did make a specific finding, so it could have been enough, maybe, but it would have delayed trial because they would be appealing that.
Oh, it definitely would play like, but it's a tenuous enough argument that I think ultimately it would have landed on structural error, because of the wording. I mean, it would have been litigated clearly. And structural error is simply where it's an automatic redo, where there's no, like, it was a clear, bright line error made by the trial court, which impacted Karen Reed's right to get a fair trial, and therefore it's getting kicked back for another retrial. So no, the question now becomes that when she does dismiss or deny the motion to dismiss, will she show the same amount of ire? Will she make the same findings with regard to the Commonwealth, with regard to their lack of candor, with respect to the Sallyport video coming in, not only coming in, but putting on witnesses, namely Buchanan, to testify that it was a true and accurate depiction of the Sallyport that day? And, I mean, you've got to feel like the answer is no, which is not how this thing's supposed to work. All right, so let's go.
Defendant's motion to present the demonstrative exhibit on Christina Hanley's testimony. It's paper 558. Is there an objection from the Commonwealth on this?
There is an objection.
All right, so I'll hear the defense on this motion.
Thank you, Your Honor, if I may. This is a relatively straightforward and relatively short.
I have a question. Did you use this last time? It looks like
we attempted to use it. We had it last time. It was shown to the witness, but it was not allowed to be introduced. And all we're asking is for that next step, that it be introduced into evidence.
Did she adopt it? Okay.
She did indicate, and that's part of my argument, Your Honor, which
So I'll go ahead. I'll hear you.
I'll truncate it. It's a relatively simple request. We just want to use the chalk that was prepared in the first trial. No dissimilarity there. It was disallowed for use by the defense to be actually used sorry, to be admitted, but it was shown to the witness. It was not shown to the jurors. The evidence, as the court will recall.
So let me just have, so you're just trying to use it as a chalk, not an exhibit.
Samantha, I'm inclined not to boost it. You're the only one do you guys think I need to boost it? Alan kind of moved away from the podium. I can hear the judge fine. And if if they're standing at the podium, a chalk is what they call that's what they call demonstrative evidence in the Commonwealth. It's something that is used to help demonstrate for the jury either a chart or a PowerPoint presentation or a large blown up picture, something that helps demonstrate something to the jury, which is typically called demonstrative evidence. In the Commonwealth, they call it a chalk.
No, we would ask that it be used as a chalk and an exhibit that's introduced. I'll take the chalk if the court wants to break it into two different pillars, but we believe that once the witness, and I anticipate based on her prior testimony that she would adopt it one more time for its authenticity or its accuracy, I should say, that it be used as an actual exhibit that goes back with the jury just for their help. The court will remember it's a very complicated.
So let me just, with that, if I allow it as a chalk, is there an objection from the Commonwealth?
Would be a partial objection to a chalk, some of the labeling. I have less concern of a chalk as I do an exhibit.
I mean, so we can take it in two steps. I certainly don't need to decide now whether it's admissible, and I couldn't. But what's the nature? Is this something?
The court will call this deals with glass. Christina Hanley spoke at length about her analysis of pieces of glass, other materials as well, but specifically as it relates to the glass, there were more than a dozen pieces of glass that she testified to. They were variously found in different places at different times by different people, and they're assigned a relatively complicated set of numbers that she utilized in her analysis.
And this is what you explained to me was the 47 pieces of glass that I asked you about last time,
No,
right?
this is more attendant to the glass in the bumper.
Okay.
The glass in the bumper, the glass that was found at 34 Fairview, as opposed to the lens material that were the 47 pieces.
Okay.
These were a bunch of pieces of glass that were originally that originated from multiple sources. Some matched each other, some did not match anything else. Some were from the same source, some were from multiple sources and different and distinct between and among each other. We reduced the very complex, the court may remember she talked about 7.14-B matched or didn't match 7.13-C, and it was very numerical and very difficult. It was difficult for me to follow. It was even difficult for the witness to follow because she continually had to resort to her own report as she tried to maintain her accuracy. So
Do you have the day of her testimony?
Oh gosh.
Ms. Little, do you have that transcript pulled up?
Yes, one moment.
So obviously, I remember her testifying. I remember seeing this previously.
I've got it. June 5th, 2024, Your Honor.
Thank you very much.
Thank you, Ms. Little. The court will recall, and I think it's clocking with the court's memory, that we did use the demonstrative aid. We walked up to Ms. Hanley. We showed it to her on the witness stand, and she did adopt it. And she indicated that once she studied it, it was in line exactly with her testimony. It's an accurate visual representation of that evidence, and it just makes it a lot easier for the jurors to find some sort of linear logic to the evidence, what matched what and what didn't. And all we're asking is that we'll use the same aid, the exact same aid that we did last time, and just ask that it be used as not only a chalk, as Mr. Brennan said, he may have a slight objection to that, but also we would ask for the next step, which the court doesn't have to decide now. I think waiting on Ms. Hanley's testimony would be apropos, and then we'll ask for its submission at the right time.
All right. What's the objection, Mr. Brennan?
This witness has a report, and a report is not admissible and can't be shown to the jury. And so to have the defense summarize her testimony when she's not allowed to put her report in herself seems a bit imbalanced. There are references on this potential chalk that lists troopers' names. Those names shouldn't be on there, but also it doesn't give the full picture of the actual testimony. The issue regarding glass, I expect, is going to be a issue in the next case. And I say that because we learned last night for the first time on a public airing of an episode that the defendant suggests that Mr. O'Keefe took her vodka soda glass out of her car. Now, that is the first time we've had any statements from Ms. Reed suggesting that. And also, there was another statement regarding a claim that Ms. Reed pulled glass from John O'Keefe's face. Never heard that before. So we have this evolving or new testimony, or statement rather, statements about glass. And so I think first, I'd like to consider this new information that we just learned last night. And secondly, I am reluctant to agree to a simple summary of part of the witness's testimony that has not only labels on it, but does not, from my perspective, clarify anything. I'm not opposed to chalks. I think chalks are helpful for both sides. And I think the liberal use of chalks is helpful, but I don't have confidence this chalk accurately summarizes the witness's testimony. I'm open to discussing chalks with the defense and perhaps learning why they think this is helpful and important, but looking at this chalk, it does not look clear to me. And I do think that the evolving nature of glass in this case is going to be an issue. And since I've just learned this information, I want to give it some thought.
Okay. All right, so Mr. Jackson, what I'm going to do is just hold off and see where the evidence is, what the two of you talk about. Maybe there's some agreement you can come up with regarding this. I need to hear more of the evidence
I
again.
understand.
And I'm going to read the transcript, so that will help me with
I think
this.
it makes sense. Mr. Brennan indicates that the chalk was not helpful to him. With all due respect to Mr. Brennan, it's not really his understanding of the chalk that is going to sort of seize the day. It's Ms. Hanley. So I do think that if the court would keep an open mind.
Sure.
If Ms. Hanley testifies, then that would be the appropriate time.
So I'll take no action on this, and maybe it's something we can address the day before she testifies or something as it gets closer.
Sure.
But the two of you should talk.
Sure.
I'm open to working with them if there's something they want to explain.
All right, great. Thank you. All right, so no action taken on paper 558.
Oh, Hank's open to working with them.
So one question, the next motion I have is defendant's motion to exclude irrelevant, inadmissible, and prejudicial prior bad character and propensity evidence. The Commonwealth has a sort of maybe a similar one that I'm not sure. The Commonwealth's motion eliminate to admit the victim's out-of-court statement relating to his state of mind. So the Commonwealth's Bins and Qualls motion, does that address the Aruba witnesses?
Aruba?
I'm just wondering if they're hand in hand. So the paper number on the Commonwealth is 585. It's got your 11 on it, though. So the defendant's motion eliminate to exclude irrelevant, inadmissible, and prejudicial prior bad character and propensity evidence. It deals with the, let's just say the Aruba witnesses. Marietta Sullivan, Laura Sullivan. Does this, Ms. Giannetti, I think this was one filed by you, maybe it wasn't. Does this include the children as well?
This does not. This is
Okay.
limited. This argument will be limited to we'll call it the Aruba incident.
Okay. All right. So given that might not include the Commonwealth's number 11, the Qualls, Bins, the defendant's statement, the victim's state of mind as it goes to the defendant's knowledge and ability likelihood to act on that state of mind.
The defendant,
So I just want,
I didn't mean to interrupt, Mr. Brennan. Do you want to?
so I just want to know if that is part of the Aruba one.
Okay.
so our statement relating to Mr. O'Keefe's state of mind is broad. It would have included the Aruba, but I can make quick work of this. We
Okay.
do not intend to introduce evidence about the Aruba event.
Okay.
I reserve the right, if the defense opens the door, then we may proceed with it. But in our case in chief, we don't intend to introduce any evidence from the Aruba event.
Okay.
Shortest
There we go.
argument ever.
All right. All right. So Mr. Brennan, you can have a seat again and we'll go through the defendant's one. That's very helpful. So I will force it as Commonwealth does not intend to introduce in its case in chief. If that changes, Mr. Brennan, you need to come to sidebar well in advance, okay? After telling counsel.
Understood. Thank
All
you.
right. All right, so that was 5:59.
So it sounds like they're not going to call the Sullivan sisters during the case in chief. That does not mean that he wouldn't try to put them on a rebuttal if the defense opens the door somehow during their case in chief.
The defendant's motion eliminate for review. Is the Commonwealth seeking a view as well?
We did not move for a view, but we do not object if the defense wants a view.
Okay.
Interesting. Interesting.
So who's going to argue this for the defendant?
I am, Your Honor.
Okay, so what's different this time around is you're asking that Ms. Reed be permitted to attend.
Yes, Your Honor.
So I'll hear you.
Your Honor, the defense is requesting that it exercise its broad discretionary powers to allow a view under Massachusetts General Law 234A.
So I'll allow a view,
Okay.
okay, but let's talk about your client attending it.
Yes, Your Honor, there was a request in there for Ms. Reed to attend. That is something that's allowed under the law.
Mhm.
If
How do you propose that's done?
if it's possible to have separate arrangements for her to be there, vis-a-vis some other transportation so that they're not all on the same bus. If the court can make that accommodation, we would appreciate it. But the most important thing in this case, Your Honor, is that there be a view of both the vehicle and 34 Fairview Road.
All right, so the Commonwealth's not objecting to a view of the vehicle and 34 Fairview, correct?
I'm not, but I do not think the vehicle should be at 34 Fairview.
Okay, what are you proposing for that?
We could make arrangements and make suggestions, but it's not going to replicate the circumstances of that evening. And so it creates an image that is inaccurate. So I do not think that the vehicle should be sitting in front of that home in totally different lighting conditions, timing conditions. And I think it can be misleading.
All right, I need some suggestions. Why don't we table this for a bit, even if we do this one tomorrow? So one of the concerns I have about just logistically, people have to stay away. When Ms. Reed's in court, there are a lot of people who come to court. So I need some assurances that there will be people kept at quite a distance. A separate car is fine. Would counsel plan on being in the car with her?
That would be fine, Your Honor.
So I need some proposal. So I need more information from both. So Mr. Brennan, I'd like you to come up with a proposal about viewing the car, a separate place or a separate time. It would be ideal if we could do it at the same time, but at a separate place. If that's what we decide, we may have to do it all at once.
I do
So-
think it's important, Your Honor, that the vehicle be at the scene just for dimension purposes so that the jury can get a sense of what it would have looked like at the scene. And I think just for convenience purposes, it saves a lot of coordination on the court's part and in terms of juror time by having it all happen in one fell swoop.
Okay. All right. So let's try and figure out some of the particulars. I would like to have Ms. Reed be able to attend. So let's figure out some particulars. All right. So defendant's motion eliminate to exclude certain witnesses before and after testimony. That's 462. And I think we can address the Commonwealth's motion for sequestration that moves to exempt family members at the same time. So who's arguing? 562. Did I say 4? Sorry.
Yeah.
562 and 576. So Ms. Little?
Thank you, Your Honor. I'm handling the motion to exclude certain witnesses. The court has broad discretionary power to sequester witnesses before, after, and during their testimony under Massachusetts Rule of Criminal Procedure 21. The defense respectfully requests that this court issue an order for sequestration in keeping with what the Commonwealth also requested. But additionally, excluding Brian Higgins and members of the Albert and McCabe families after they testify.
So do you mean after the evidence is closed?
I mean, after they've taken the stand.
So after they've taken the stand, but so witnesses are sequestered not to influence any testimony. So once the evidence is closed, just before closing arguments, are you saying they should not be permitted to come into the court for closing arguments?
Yes.
Focus on that part of your motion.
Yes, Your Honor. We're asking that they not be able to attend closing arguments, and this is why. As the court likely recalls, at the first trial, members of the Albert and McCabe families continued to attend court after their testimony. During closing arguments, Colin Albert, Ryan Albert, and Jennifer McCabe were all seated in the jury box with the O'Keefe family. At least one juror who was seated in this case indicated to a reporter at Vanity Fair that she felt intimidated by their presence at closing arguments. Your Honor, a sitting juror reporting feeling intimidated by the presence of third-party culprits towards the close of the case is highly concerning.
Was this a deliberating juror?
I don't know. She was, or he or she was anonymous.
Okay.
And Your Honor, that was by design. There is information that the Massachusetts State Police and the District Attorney's Office wanted to have the third-party culprits seated there during closing arguments. And so on that basis, the defense is requesting, in order to protect there from being any sort of undue influence or intimidation, or even just the potential that a juror might feel that way, as we know at least one did in this case, we're asking that they be sequestered after their testimony and during closing arguments.
What's your position on the Commonwealth's motion to exclude the family members of both the defendant and the victim?
I believe that the sequestration order, yes, we join in that request.
Okay.
The only exception I would note is that experts should be able to obviously watch other expert testimony that deals with their.
All right. So obviously is not something it should be in a motion. Okay. If you've got an agreement that each other's experts can be in the courtroom during the testimony, that's one thing, but it's not obvious that they're permitted. Okay.
I just wanted to make sure that that would be excluded from the order that the Commonwealth proposed. Because the way that they wrote it, it says all witnesses. And I'm guessing that, I won't speak for Mr. Brennan, but I'm guessing that they will want their experts to watch our experts and vice versa.
All right. So you all need to talk. All right. And if there's a disagreement, you need to put it in writing. Generally, experts are permitted, but it's not a given. Okay. All right, Mr. Brennan, do you want to weigh in on people being able to, I'm concerned about after the evidence is closed.
I think it's unfortunate that not only a time-honored tradition, but an entitlement for a witness after the evidence is closed to come into the closing and watch the closing. The defense tries to take an opportunity to provide an unsolicited bashing on their targets. They name Higgins, Albert, they invoke those names, they characterize third-party culprit, and they suggest that some anonymous person was uncomfortable.
Well, a juror.
It seems as though the presentation has a deliberate point to promote a cause, but it doesn't have any sense of balance or fairness whatsoever. Witnesses all witnesses from either side should be able to come into a courtroom after the evidence is closed, the sequestration order has ended, and watch a closing. Grace can be offered in these circumstances sometimes, and that's what I've tried to do in my motion. Ms. Reed has 3 potential family members who are potential witnesses for the government. And certainly I would have a right to try to ask the court or insist that they should be sequestered. But I've specifically asked that they not be sequestered. I think that an accused has a strong need to have family support in the courtroom. It's not in the benefit of the government or the Commonwealth, but it's fair, it's just, it's graceful. And I think that Ms. Reed's family should sit through the court testimony, even if they're called as witnesses, as should Mr. O'Keefe's immediate family. The idea that witnesses should not come in after a evidence rests and during a closing, not only does it seem quite unfair, it doesn't seem to have any basis in law, in justness, in courtesy. And so I ask you to deny the idea that these targets of the defense should not be able to attend the closing. But I do ask you to endorse my motion that would allow family members to have the benefit to sit through the court proceedings, even if they may, or even if they do become witnesses.
Okay,
Your Honor, if I could address one issue.
sure.
There is some additional information. I was hoping we might be able to address sidebar because it is subject to a protective
Okay.
order, but I would
Run
like to
over.
make a record.
Let me see if I've got any blooping. We had enough blooping.
So I'll
Little
take
bit
a
of
closer
blooping.
look at both of these and have something later.
I forgot I let the dog out. He's excited about all the birds running around outside.
All right, so Ms. Giannetti, I think this next one might have been yours. I could be wrong again. Maybe it's just that you filed some. It's paper 565, defendant's motion eliminate to prohibit testimony regarding funds paid to experts for purposes of voir dire.
That's also mine, Your Honor.
Okay,
I believe the Commonwealth has indicated that they will agree to that.
okay. All right, so paper 565, allowed by agreement. So 566, defendant's motion for panel voir dire. Who's arguing that?
That's me, Your Honor. Thank
Okay,
you.
so all I need you to really focus on, of course, I'll give attorney conducted voir dire, but why don't you focus on panel voir dire?
The request is pretty straightforward. We would maintain a categorical list of topics that is in line with the statute, previous experiences with the criminal legal system, characteristics of the case, including media attention, things of that nature, biases in favor of law enforcement or vice versa, personal beliefs about driving under the influence. We think that's attendant to this particular case in particular, involvement in any relationships involving domestic violence, involvement in motor vehicle crashes, those categorical issues, whether they've ever been victims of violent crime and their general ability to be fair and impartial in light of Ms. Reed's constitutional rights to.
Okay, we covered all of that last time as well, right?
And that's exactly right. So we're not asking to change the categorical subject matter. We just believe that a panel voir dire conducted, at least in part, with limitations, obviously, time limitations and subject matter limitations by the attorneys would be of great assistance to both counsel, both the Commonwealth and the defense, in determining jurors' ability to sit through an extensive trial, a complex trial, and something that's going to be obviously hotly contested. The chemistry between and among jurors is more borne out if there is some, at least a modicum of panel discussion between and among the jurors and counsel who will be handling the case on behalf of Ms. Reed and on behalf of the Commonwealth. We don't think that there's any prejudice to either side, certainly not to the Commonwealth, certainly not to us. I think all of us would benefit, including the court, would benefit from being able to impanel a fairer and more comprehensive jury.
Okay, what's the Commonwealth's position?
Of course, we defer to the court. However, we prefer a questionnaire. If we have a panel voir dire, there will be quite a bit of contest on the subject areas, the limitations, the parameters. I wouldn't say anticipate, but I worry that it will digress into trying to craft the argument, the direction of argument in a way that's favorable to each side's cause. And that really isn't the purpose of it, but that seems to happen in the limited times I've engaged in it. And so I think the questionnaire is more structured. It allows for all the different subject areas that are important to both sides. And I may misunderstand, but I think the court allows follow-up on questions where there is any inquiry or concern or follow-up that's reasonable and necessary. And I understand that that has been a liberal application, and I think that suffices.
The only thing I would say to that, if I may speak from here, the only thing I would say to that is I completely agree. I think a questionnaire is enormously helpful, especially as it pertains to a panel voir dire. And quite frankly, Your Honor, in my experience, and that's what we do where I'm from, is panel voir dire consistently. It's faster. It's actually much more efficient to do a panel voir dire than it is to do an individual voir dire. That's all I'll say about that.
So I'm a huge proponent of panel voir dire in the right case. My biggest concern here, frankly, if we didn't have the inordinate amount of publicity on this case so close to trial. I heard that there was something last night. It's been in the news, right? And it's continuing. It's because of that. I'm afraid it's just going to blow up
the
the
news
panel.
last night?
So, and I have a lot of discretion here. I'm not going to allow panel voir dire. I will allow a robust, as I did last time, voir dire at sidebar. We're also on for final trial conference today and tomorrow. So I need a list of witnesses from the defense. I need you to fill out a report so that we know exactly what is still left that we have to deal with. And jury voir dire is a very important part of this. So I expect, as last time, to be able to use a questionnaire, but I want you to agree to it. And if you can't, I need that. You know, I need that by the end of today if you're not going to agree to it. Have you proposed a questionnaire? Have both sides talked about a questionnaire recently?
We haven't, but we do have the advantage. Both sides has the advantage of the one from last year. There may be some adjustments, but I think we have a backbone to start with.
So let's do that. What Mr. Brennan's new to the case, what I need in a questionnaire is it has to be one page, both sides, no more than one page. At the end of our hearing tomorrow, I would like to talk about the particulars of it. We have a huge amount of jurors coming in, and I have some ideas on how we might best utilize that with the questionnaire, but I need to talk to counsel about that at the end of all these hearings today. All right, but just to be clear, no panel voir dire on this case, unfortunately, I think because of all the publicity. And we'll do extensive voir dire at sidebar and the questionnaire. So 566 then is denied because it's requesting panel voir dire. 567, defendant's motion for order prohibiting the Commonwealth and its agents from speaking with or having contact with any witnesses once they've taken the stand. So
Why do we need to
is there
hear
an
it?
objection to that, Mr. Brennan?
Right.
There's not, I believe that rule should apply to both sides. I have no objection.
Okay. Mr. Jackson, do you agree it applies to both sides?
Yes.
Ms. Little?
Thank you.
Okay.
Thank gosh. I thought they're going to have a hearing on
Right,
like
so that, Mr. Clerk, 567 allowed as to both sides.
right. That means you don't talk to the cops either there, Brennan.
.570, defendant's motion eliminate to exclude irrelevant, inadmissible, and prejudicial evidence regarding alleged harassment and/or intimidation of witnesses.
Mm.
All right.
You need to argue. Why
Thank you, Your
can't she
Honor.
just ask the questions she has?
The first trial, I'll note, was riddled with what we believe to be inadmissible and highly, highly prejudicial testimony from a bunch of witnesses who took the opportunity to describe harassment and distress that they felt from third parties, both on social media and otherwise. No third party, including any blogger, any social media personality, any member of the public, no third party speaks for Ms. Reed. No third party speaks for the defense. No third party acts on behalf of Ms. Reed, is directed by Ms. Reed or the defense, or is under Ms. Reed or the defense's control. None. There were very obviously vile acts that were described during the course of the first trial in these witnesses' testimony. To the extent that they did occur, they are obviously in no way condoned by the defense, by Ms. Reed, or anybody connected with the defense in this case. And they're in no way connected to Ms. Reed or the defense. And notwithstanding that, the witnesses strongly suggested that Ms. Reed and the defense itself were somehow responsible for these alleged and very reprehensible things that they were describing. In one notable instance, Jennifer McCabe recounted being harassed by a blogger. She didn't name the blogger, but she said, quote, "The defense is very familiar with this person," end quote. That was her trial testimony, and she looked right at the jurors when she said it. The very obvious overture was, "You know who this is, Mr. Jackson. I was the one cross-examining her, and you're responsible for it." In some way, shape, form, or fashion. She outright suggested to the jury that Ms. Reed and the defense were responsible for the acts that she went on to describe in great detail, in which we agreed, if they occurred, are vile, reprehensible, unacceptable. There are clearly, as we all know now, there are clearly people out there who are very deeply concerned about what they consider, the others consider, an unjust prosecution of an innocent person for a crime that she did not commit. There is an enormous amount of emotion injected throughout the community, this community and beyond, and we don't control that. And if people have suffered as a result of that, Ms. Reed very specifically should not be the one to have to bear that burden, and she did in the first trial. Those individuals out there who are emotional about the case, who are a proponent of one side or the other, they speak for themselves, they act for themselves, they act on their own accord. They certainly don't act at the direction of the defense or of Ms. Reed. And to allow these sort of what ultimately can only be described as salacious anecdotes into evidence, coupled with the sobbing and the crying and the breaking down on the witness stand, which also happened, it serves to visit an extreme and an extraordinary prejudice against Ms. Reed, very, very specifically and very targeted like a laser on her. And it's for conduct that's completely out of her control and completely unassociated with her. What may be most galling about the Commonwealth's presentation of this evidence in the first trial of witness intimidation was that they were in possession. They actually knew. Mr. Lally, Ms. McLaughlin, they knew at the time the information was presented and propounded in front of the jury that a grand jury had been impaneled to hear evidence on whether or not Ms. Reed was in any way liable for witness intimidation, witness harassment, or anything associated with that.
So the grand jury has a particular standard, right? Not any way, right? Probable
I
cause
understand
standard,
that.
right? Okay.
Ham sandwich. Judge
Notwithstanding that standard, the question was she in any way liable for that harassment and intimidation? And that standard is extremely low.
Ham
We all know
sandwich.
the ham sandwich anecdote.
Hey!
And even the grand jury said, no, there is absolutely nothing to see here. There is no evidence that she was responsible for intimidation or harassment such that they determined that there was a no bill. And what is bothersome is that the Commonwealth was aware of that and didn't disclose it. We didn't find out about that until in October. I think it was an October notice of discovery. when we finally found out that a no bill was issued indicating that Ms. Reed.
When was that no bill issued?
You said when or where?
When?
When? I want to say March 23rd, March 27th is what I'm being told. It was late March, before the first trial. And they knew this, and they didn't provide what I believed, and I think what the court would have ruled would be exculpatory information to us to cross-examine these witnesses who say, hey, look, I've suffered at the hands of the community, of these bloggers.
So my memory is I kept it out, and then I have a very clear memory of you opening the door with Jennifer McCabe, and it came in through there.
So the court did make that ruling that ultimately, if the door is open, these witnesses are going to be able to talk about it.
But I kept it out prior to that.
Understood.
Okay.
I don't want to revisit that issue. The court made its ruling. I didn't think that we had opened the door. It was whatever that door was. It was on some very, very significant lubricant. It was going to be opened very easily.
Read the transcript.
I have several times. In any event, I believe that the court should make the exact same order this time and have a more defined, we should have a more defined understanding of what would reasonably open that door. I didn't think that I came anywhere close to it. The court disagreed and the information came in. But it's so prejudicial. It was so extremely prejudicial as to Ms. Reed that I think we need to revisit that issue and get a more clarifying order about exactly what would be required to open that door. And then we can reasonably, as the defense, we can reasonably sidestep that as best we can. I wasn't able to do that in the first trial because I didn't think that I had even approached the line, but ultimately the court disagreed. So what we're asking in this instance is that we get a clarifying order that it is not admissible. Obviously, if we walk in and say something about witness intimidation, you've never been intimidated by anybody, have you? Obviously, that would open the door. That's not what would happen. That's not what happened last time. What happened last time was Jennifer McCabe basically decided that she wanted to talk about that issue and sort of walked through it, at least in my view, having reviewed the transcript. In any event, I think the court understands what our concern is with regard to this subject matter. We don't want a free-for-all of people, one person after another walking into court and basically lambasting the defense for all intents and purposes about things that are completely out of our control. Even if there is some suffering by the public or by bloggers or by whomever that these witnesses have had to undergo, that is not at the hands of the defense, and we shouldn't have to, Ms. Reed very specifically, should not have to suffer through that testimony when it looks very, very clear that at least the Commonwealth wants the jurors to believe this is all at the hands of Ms. Reed, that she's been the one engaging in this, or the defense has, which is just not true. So we would ask for a clarifying order on that issue very specifically.
Mr. Brennan.
Oh, this ought to be good in a really, really bad way.
I can appreciate the defense wanting to identify the line in which they would open the door to evidence about harassment and abuse of witnesses. I understand why that would be important. But to convert that into a speech that absolutely defies reality and grossly misstates the history and facts of this case is beyond me, It wasn't just last night when Attorney Jackson and his colleagues appeared on a documentary where Ms. Reed talked about speaking frequently to Mr. Kearney, sharing anything public with him. And you would have to choose to be oblivious to think that information that is shared was then not generated to intimidate and harass witnesses for 2 years.
It was shared
In
for
fact,
that reason.
Mr. Kearney has over a dozen indictments for just that. You've had an opportunity to hear the conversations recorded with Gretchen Voss. You've heard about the tactics used by the defense in the dissemination, not just of public information. So to try to make a public record that is so grossly, not only inept, but fraudulent, I don't understand the purpose of that when the simple question is, what is the threshold of opening a door? We have a motion later this afternoon in another courtroom on this very issue. And I'm not going to go through an entire resuscitation of the evidence or information that I have, because that inevitably would be unfair. But it is unfair to stand up here at this podium and suggest for a second that Ms. McCabe is using a witness box as some type of forum. She didn't drag herself into this case. She was dragged into it. And to suggest they can stand here and bash witnesses in the text of their argument, unsolicited attacks, because it pleases them and fits their narrative, is something I can't just sit by and listen to. The Commonwealth, the prosecutors weren't outside patting their bloggers on the butt for a job well done after witnesses were harassed at the family events. That didn't happen.
God.
And so if the issue is, what is the threshold when Mr. Jackson opened the door? Well, you can read the transcript. It's very obvious. Open-ended questions, personal attacks, baseless accusations. That opens the door. And it will open the door again, I suspect. And we'll be prepared. I think the issue is really a trial issue, and an attorney having control of their questions so they don't open the door. That really is the issue.
So do you agree it doesn't come in the Commonwealth's case in chief with these witnesses?
I don't think it ever should have come in the case in chief, and I don't think it would have until I saw the very clear questions that opened that door. I have no intention of raising a collateral issue or trying to present prior bad acts that I haven't sought admissibility for. So I agree. I agree.
Okay.
Your Honor, if I may very briefly.
Sure, just give me 1 second. I want to take one note, okay?
Of course.
What do you think that note was about? What did he just say?
Said he agreed that it wasn't going to come in during the Commonwealth's case in
All right,
chief,
go
I'm
ahead, Mr.
assuming.
Chairman.
I just wonder if where this ire and these invectives from Mr. Brennan come from. He said that I stood up here just a second ago and attacked witnesses and bashed witnesses and made fraudulent statements. Was he listening? I didn't bash a witness. I didn't attack a witness. I didn't make any fraudulent statements. The Commonwealth made their best effort to tether Ms. Reed to Aiden Kearney. And they did it through a grand jury. And those members of the grand jury said, no, it's not true. It didn't happen. That's what they said at the lowest burden known in criminal justice. So Mr. Brennan can stand up all he wants and say, I saw a TV show and I saw this and I heard an interview, and clearly there's been communication between Ms. Reed and Mr. Kearney. Sure, there may have been communication. That's very different from directing witness intimidation, directing witness harassment for the purposes of undermining a prosecution. That's what they've accused her of, and they failed. And then they kept that from us when they failed and allowed this sort of fabrication of
He's got to
the
choose his
witnesses.
words.
And I'm not
carefully
saying
these
that
days.
the intimidation that was described on the witness stand was fabricated. That's not at all what I'm saying.
He's
maybe
got
it's
to
true,
clear,
maybe
he's
it all
making, like
happened.
all his words clear.
What was fabricated is that it was connected to Ms. Reed or connected to us. So nobody's up here, Your Honor, and I take issue with Mr. Brennan's tone and tenor. We can all be professional. We can all advocate very zealously and robustly. But let's keep it professional. I didn't stand up here and attack a witness, or what did he say? Bash witnesses. Use this as an opportunity to bash people. But we could calm the drama down just a little bit and probably get a little further.
And the
All we're
rhetoric.
asking is that it not come in, and I will stipulate and agree with Mr. Brennan that this not come in the Commonwealth's case in chief, and we will be very mindful of what would conceivably open a door to this kind of testimony. And I'll probably seek the court's guidance before I ask a specific question that I think comes anywhere close to that. We'll ask the court's guidance by coming to sidebar, and I think that could resolve the issue.
Okay. Thank you. I'm going to look at this a little more closely.
Why? So she doesn't want to agree that it shouldn't come in during their case, and she's going to look at it a little more closely. What?
All right, the next one is paper 571, and the Commonwealth's corresponding is your number 12.
Like, it's her call. Both sides say we want jury, voir dire in a panel. That's her purview. That's her call. Both sides have just said this should not come in during the state's case in chief, and she's taking it under advice. She's looking at it more.
Well, I don't know if she's going to be privy to the grand jury testimony. I mean, typically, I don't know that she would be, but I'm like, the Commonwealth absolutely has been putting that narrative out there that Karen Reed and the defense team, at the behest of them, was guiding Aiden and everybody else, the whole crew, with Aiden being the kind of the leader of that crew, and that they were doing it at their behest. That's been the narrative the Commonwealth has put out there.
I understand that, but how does this all, if she agreed with what both sides said, that this does not come in the state's case in chief, that means that the prosecution would have to tell their witnesses, you cannot mention the harassment. You cannot, you can't say that, period. And my whole thing is, what does she need to take under advisement? What does she need to keep considering? They both just said that that's how they thought it should proceed. And unlike how the jury should be impaneled, where that's her world, doesn't matter what the two of them say, she can take it into consideration.
Babe, you got to turn your phone on mute. Is that you dinging like that? It's annoying.
Yeah. I guess it picks it up more when I don't have the
we all can hear it pretty well.
The mic and the headphones on. Because I'm waiting if the Zoom opens up to just hop off this and hop on that. Anyway, I just think it's interesting that she still wants to think about it.
We can still hear it, babe.
I don't know. I've got my notifications. All right.
Yeah, no, I see what you're saying. Yeah, I mean, it seems like the resolution was offered to the judge by both sides, and I think that in terms of Alan Jackson saying, look, anything, like, I'm not going to, even though I disagree with you that we opened the door in the first trial, the way that I'm going to remedy that personally during my questioning is I'll come to you before I ask the question, just to make sure that in your estimation, that doesn't open the door.
But she also said before, if any witness brings it up, then she was going to if they initiate it, she's going to let it in. It wasn't only like open the door. It was like, if this witness,
Yeah, I mean, but there's two issues. There's the intimidation aspect of it, which Alan clearly acknowledges may have existed. But the other issue, the side issue, is, was it at the behest of the defendant or her team, which is hideously unfair. If they don't have any evidence, which it sounds like they don't, that was being done at the behest of the defendant or her team, then that coming in is hugely prejudicial to Karen Reed. So, I mean, I don't know what she's going to look at, but I agree. I think she has everything there to have made that decision. But I guess we'll see.
our paper 586. So the defendant's moving to exclude the serum plasma ethanol concentration, blood ethanol.
Oh, and I did want to ask, I saw Oasis asked a good question. I'm curious as to your thoughts when Brennan said, I don't know, you were on, I think, when he said that we have a hearing regarding this exact issue in another courtroom. What your take on that is. Now, I know Aiden's case is up, but as far as I know, Brennan's not the one prosecuting it. So like,
No, he
I
might have been
don't know
using
what
the
they're talking about.
using the royal we for the state of, for the Commonwealth. So I
Like
think they're
brother counsel type
right.
thing.
I think they're
Yeah.
talking about the wasn't there some motion or argument for their records in that case? Or was
Yeah.
that in this case?
Oh, that's you nailed it. That's what it is. So I think, but I don't know if he is now having to argue that in that case as well. Cause yes, he's seeking. I think he may have tried to intervene over there in order to try to get those phone records. Cause he's definitely trying to get those phone records.
I don't know why he would need to intervene there. He could just ask for it here. Like
Maybe
that.
he did ask it here. I've read the motion. I can't remember if it was, but like Judge Canoni doesn't have any. Like, I mean, can she rule, you think, in terms of evidence in an entirely different case being
Well,
tendered
she can
to
rule
Commonwealth in
whether
this case?
she can rule whether it's whether the state has the right to compel Turtle Boy or whoever else to turn over their cell phone in this case. Like if they're seeking it and the defense is saying that they have no legal basis for it, I think it would be their lawyers also having to come in, like the and say no, like they
Yeah,
did
but if the grand jury
newspaper.
came back with no true bill, isn't that enough for her?
I would think so.
I mean, I'm assuming the Commonwealth had something that they thought might be enough to reach that very low burden in terms of a grand jury.
Right. And I don't know
Like
why
a
he's
fishing
acting like
expedition.
sharing information with Aiden is somehow that you can make a logical leap from she shared information to she was part and parcel of having him use that information to harass witnesses. That's an absurd jump in logic.
Yeah, no,
No factual basis.
Aaron, yeah, I know Brendan's a defense bar guy. I've disavowed him from the defense bar. He's now a turncoat. There's no undoing what I've seen him say and do in this
Right. He
particular
could have
trial.
handled this. He could have handled this in a much different way, a much more.
He sounds like he's been part of the Commonwealth his entire career. That's what he sounds like. It's insane to me.
And he's supposed to
Insane.
do a good job for the Commonwealth when he gets hired. That's not what Bob and I are saying. We're talking about
Right.
the dirty tactics he's playing.
Yeah, I know you were, Aaron. Aaron said she was being facetious. Yeah, I know.
Oh,
It's still it bears repeating. I think I don't care if he was a prosecutor before. Once you go from that side to the defense side, you then become a defense attorney. And like you rarely see it the other way around. You rarely see defense attorneys going and becoming prosecutors because it's not in our DNA. It's a whole different thing from dealing with human beings, dealing with defendants, dealing with their families, to going over to the prosecution side where you're dealing with paper and names and facts, and that's it.
well, they're
Like
dealing with victims and victims' families.
they,
I mean,
they do, but they don't.
right.
I mean, we've seen it, it's like that's always my complaint. Like, post conviction in a case, victims' families are left hanging a majority of the time by prosecutors' offices in terms of, can you help me understand the appellate process? Like what's happening here? Because victim families are tortured by that for decades sometimes while things are under appeal and they have no idea what's going on. They don't know what it means. And, prosecutors typically don't walk them through that. I've found in my own personal experience. So
And
Mineral
Emily, yes,
concentration.
this is the only case he's prosecuting.
Conversion and corresponding retrograde extrapolation analysis. So who's arguing this for the defense? Because I'm going to ask you whether you want to argue your opposition to it or have the Commonwealth make their argument for admission of it. Who's arguing it for the defense?
Your Honor, I am. And to
Okay.
answer your question, the defense preference would be for the Commonwealth to go first. And
All
we
right.
would respond, including with regard to the motion.
Okay, so Mr. Brennan, our paper 386, your number 12.
Your Honor, our paper number 12 seeks to admit the results of the defendant's blood draw at the Good Samaritan Hospital and the resulting serum conversion and retrograde extrapolation. This being a OUI manslaughter and murder case, the statutes that the defense cites don't apply. This is not a simple OUI case. We expect that we will have a witness from the hospital describing the protocol. We will have a witness from the hospital to testify about the blood draw, and we will have an independent, or we'll have an expert to talk about the blood serum conversion. These medical records are admissible. We cited Chapter 233, Section 79 as a business record. I know the defense takes issue with that. However, these records are routinely admissible. Commonwealth v. Hallinan, 491 Mass, 730, page 736, note 9. Blood alcohol serum conversion and retrograde extrapolation is admissible. While the standards may be different because it happened at a hospital, these are agencies, hospitals are facilities that have standards that comply, that are trustworthy, and this evidence should come in pursuant to those cases in that statute.
All right, now I'll hear you, Mr. Alessi.
Thank you, Your Honor.
What? We didn't focus on anything that matters, like her consumption of alcohol last time.
Attorney Brennan misstates our position that is clearly set forth in our papers.
Yeah.
We are not citing to statutes that discuss consent of Ms. Reed. So I just want to take that because he's conflated issues and not addressed the main issue. Attorney Brennan just said that the results are reliable, that he has raised that because not only is there no proof that the results are reliable, there's proofs in the first trial admissions as by Mr. Roberts, as well as impliedly by Ms. Knowles, that they're not reliable, and here's why. There is no record evidence as to the method of the hospital determining those levels. Specifically, with regard to the medical records in the chemistry section of those, it says in an annotation, the drug testing, this report is intended for use in clinical monitoring and management of patients. And here's the key statement. It is not intended for use in employment-related drug testing or court-related proceedings. And the issue with regard to the reliability of the testing is it is not stated the basics to go to reliability. Specifically, there's no documentation of how the alcohol test result was obtained, through what procedure, by whom, and the key, what manner of testing. There's two ways to do it: gas chromatography and enzymatic testing. And there's a huge difference in the reliability between the two. There is no record evidence, and it's the Commonwealth's burden of proof to establish reliability. There's no evidence of any of those foundational aspects with regard to the testing. So with regard to those test results, the Commonwealth has to establish the reliability. It is not enough for the attorney for the Commonwealth to simply to stand up and ipsy dixit in saying they're reliable when there is a lack of the information of the factors I just rehearsed with regard to the matter. And another key aspect, which is conceded by the Commonwealth, they concede that the testing did not occur at an accredited laboratory. They concede it. And it's in every single report of the Commonwealth. And we put that in Exhibit A to our motion. For example, it's Exhibit A, the very first page, COM 000994, serum plasma conversion report. It states 2 paragraphs under the chart with an asterisk. The ethanol result used in this serum plasma conversion report was provided by an external party. The testing to obtain the ethanol result was not performed at the Massachusetts State Police Crime Laboratory, and therefore this report does not fall under the laboratory scope of accreditation. Not the words of the defense.
So that's from the State Police Crime Lab, right?
Pardon me?
That's from the State Police Crime Lab, right?
That's correct. And with regard to the next document, which is
Y'all understand that ipsy dixit just means he just says shit, right?
No,
that's
they
Latin for
do,
it's just
but-
he just says shit.
They do, but what you might not know is just that Melanie Little, attorney Melanie Little, she's ipsy dixing everything like that. That's like a running joke, and she's always like,
Yeah, I know that.
oh,
I know Melanie's all about some ipsy dixit, but that's just Latin for he just gets up and says shit.
our Exhibit B. In terms of changing that conclusion in that statement, there is nothing in there to remedy that statement. Exhibit C also mentions, and this is NDAO 296, under background, it's the same statement. The ethanol result used in this retrograde extrapolation report was provided by an external party. The testing to obtain the ethanol result was not performed at the Massachusetts State Police Crime Laboratory. So what we have with regard to the foundation of reliability, we don't know what type of test result this third party did, gas chromatography or enzymatic, and we don't know any of the other factors, and it's the burden of the Commonwealth to establish the reliability of that testing. So in conclusion, Your Honor, given that the Commonwealth has not satisfied its burden in this regard, the testing that has been performed is not reliable.
All right.
It should be excluded.
Okay. Do you want to respond, Mr. Brennan?
I would suggest the court look to Dr. Fowler's testimony. He testified how
Make it
blood
to
was
my
taken, how it was preserved, what tests were conducted in the lab at Good Samaritan Hospital, how the lab is accredited. And this is the same issue argued at the first trial, but inevitably Dr. Fowler's testimony is what establishes the foundation for the admissibility.
Okay,
May I just respond briefly?
sure.
Thank you, Hunter.
she might allow him to build the
Your
foundation.
Honor has often said that this is a new trial. The Commonwealth for this trial has to establish that foundation. They can't point to the testimony in another trial to establish it. That should have been in their motion in opposition, that they should have put that in assuming that that is accurate. But it is not in their motion here, and that cannot be relied upon to defend the lack of
Can't just say
reliability with regard to those factors. And I will also note that none of the witnesses I just rehearsed, Mr. Roberts nor Ms. Knowles, if we're going to talk about the first trial, ever referenced that as curative of what they said for lack of accreditation. And if we're again going to go back to testimony of the first trial, Mr. Roberts on cross-examination clearly expressed concerns with regard to these foundational absences with regard to testing. Thank you.
Okay. I think we have time for one last motion before we take the morning recess. Paper number 574, defendant's motion eliminate to exclude witnesses' prior criminal history. Who's arguing that for the defense? Is there no objection to this? This is regarding Richard Green.
It doesn't qualify pursuant to the statute.
All right, that was my question to you. How do you expect to get it in?
I don't.
Okay. All right, so this motion is allowed. That's 574 is allowed, Mr. Clerk. All right, so what I'll do is I'll see counsel at sidebar regarding scheduling.
Bloop, 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 bloop. All the blooping. We have a fair amount of blooping.
All rise for the court, please.
You are muted.
Oh, she's just leaving.
Did she say how long the break was?
Maybe bloop forward. I didn't hear it.
Loop forward or backward?
Well, yeah.
We're still at sidebar. 15 minutes for the morning break. Yeah, I don't know if Aiden's hearing is being streamed. We got it after the fact in terms of
Are you live?
no, I'll get live though.
Because you might have 15 minutes.
I think I might. I'm not even blooping, I'm dragging. All right, now we're live.
Hit the play button at the bottom.
Yeah.
There you go.
I did it.
You did it.
I did it. I don't know how much more there is. There's
I must be at the end of
more.
this call. Judge must go through the whole call before he takes Zoom because I know it's not. He doesn't usually do Zoom, but this was a status date, so
What courtroom? What county?
Winnebago.
Oh. So I'm trying to see. Does anybody out there have a list of all the pending pretrial motions? Motions in Lemonade? Let's see.
You just have to say lemonade if you're saying lemonade.
Oh, motions in Lemonade? What do you mean? You skip the whole motions? Oh,
No,
motions.
motions. Oh, is it motions? Yeah, motions in lemonade or motions and lemonade. I don't know. We'll need a cupcake to tell us because that's also a Melanie thing.
Some have said it's an Emily thing.
Oh, maybe it is an Emily thing.
I think it's a both of their thing. I don't think that anybody like invented that it sounds an awful lot like lemonade.
Well, someone said it first.
Tracy, what do you mean? Yes, 601. Was that to me? I guess what I'm asking is, does anybody have a
And they do. And I
list?
think someone said, look at the description on
Mel
Andrea's
channel?
live. That Andrea like must have them all spelled out in her description.
That's nice.
And I found it. It was Asher. Thanks, Asher.
Let me see. I'll pull it up.
When's Andrea coming?
Andrea, in what I think is going to be a phenomenal live on Thursday evening, we are having Andrea join us because I was able to get Stacy Eldridge, who is she's a digital forensics expert, and she was the digital forensics expert for Richard Allen at his trial. So she's going to be coming on so that we get to hear all the things that she testified to. It's going to be a very, very good live. So we hope that you'll all join us. That will be, and it's earlier because Stacy has she doesn't go deep into the night. So we're starting at 5 Central Daylight Time. And we'll go as long as we can keep Stacy hostage on the live. I'm sure there's going to be a lot of questions. If you guys have questions, if you follow the Allen case and you've got any specific questions, please post them in the community chat in our community page.
And you'll have a spot for members too.
Definitely.
Okay.
Definitely. Members will get first priority for sure. So we're excited about that. Should be really, really interesting. And, I mean, we're going to get to hear it from her firsthand, what she testified to. Obviously, yeah, the phone jack, that being engaged. There's a lot of fodder there that we can get into because everything relating to the phone. I'm going to be curious as to whether or not she was looking at the Bridge Guy video that was released. I want to know about this kind of mystery picture of Abby on the bridge that seemed to not come from Libby's phone, that was found on the internet somewhere. There's a lot of questions out there right now, kind of in the social media world, about a lot of things with regard to that phone. So who better than to have the person on who has examined it and the
Babe, check your
extractions.
text.
Huh?
Check your text and just let me know if that's accurate, or text me back, I guess.
Okay.
It has nothing to do with this, so you don't need to discuss.
I'm reading it. What am I?
You're just telling me if it's something different, you text me. Otherwise, say you can
Oh
just
yeah,
tell.
that's fine.
Okay. So thanks, Meg. Bab, are you going to cover TB arraignment today?
Yeah, I just said I don't know if it's being streamed.
Oh yeah.
I don't know.
Thanks, Meg. Christy Silo, thank you for your generosity. Cool lady, thanks for your generosity. She says, Allie and Bob, just want to thank you for all you do to educate us on the law. The compassion you show is beyond words, in a good way. The rants brighten my day. Good to hear.
I mean, sometimes we get pissed.
And thanks again, Meg, for your generosity. Bab and Allie, how do you feel about people saying the Bridge Guy video is actors? What? I can't. No.
Wait, the
Who said
Bridge
that?
Guy video is actors?
Who's saying this?
I don't know. I don't
No.
know. I've
The answer is no, because we know where it came from and have confirmed the legitimacy of the video.
No, I don't think that's what they're saying. I think they're. I don't know. There's all kinds of stuff out there.
What does that mean? That's not what they're saying.
I don't know. People think that it's a deep fake.
That's what I'm saying. We're confirming it's not a deep fake. They're not actors. Those are people.
No, they're confirming that somehow, or they're trying to say that the state somehow made the deep fake and then put it on the
phone.
I don't know.
And then all the experts couldn't find any evidence of this deep fake.
I mean, the more far afield you get into that kind of shit, the more it sounds tinfoil hatty to me.
Yeah, to me too.
To me. So I'm just, I don't. To me, the real question is,
how could they make a video before they had a suspect and then leave the suspect for 5 years? If the whole point was to eventually frame Richard Allen or someone, well, they set up the frame and then took that long to frame somebody. They had a bunch of people saying it looks like this guy, looks like that guy. They could have framed just about anybody in 5 years. Why the hell would they wait? I'm going to say I don't think that's a thing.
No, to me, the bigger question is when we're talking about that picture of Abby alone on the bridge, that still photo.
That's weird. That one's bizarre.
Well, but what's bizarre about it is that she's relatively, it seems to be very close to where the video starts.
Right, and there's no
And there's
one
no
there.
one behind her. That's the part that, I mean, there's a lot about that video that's disturbing.
Right, and you said when you first saw the video that you thought there was no one behind him, but that could have been your mind recalling the still frame. You know what I mean?
Wait, well, no, like when I'm telling you, every single person in that thing, aside from the murder shits, said that they didn't see initially. I'm talking about like the very first shot when you first see Abby, because you can't, like, you can see he's barely visible. Now that we get to see it 100 times, you can see he's there. Because even Lauren from Hidden True Crime, who's very much pro Alan's guilty, said the exact same thing. Like that, I didn't see the bridge guy initially. Andrea said it. Like no one was trying to put out a narrative. We're trying to watch this video for the first time ever, and and you're trying to take it all in. Like I said, obviously when we get that's the point. Now that we all get to see it, now we can see what's what. I wasn't trying to put any narrative out there. It's what I didn't see or I did see. Obviously, when you get to like 10, 15 seconds of the video, you can see the guy back there. But initially, he just seemed kind of appear because I didn't see him because it was a split second that you're watching it.
Right.
And
What
for
do you say
me,
to Stephanie?
what?
What do you say to Stephanie?
Family hug. Welcome to the family. Allie's fully leaned into family hugs, but if you guys remember early on,
people like them, so I'm letting you give them.
That's right. People do like them.
Thanks
People
again,
like
Meg.
hugs. Well, most people like hugs. Some people don't like hugs.
No, our sound engineer doesn't like hugs.
He's not a hug guy.
It as a social, because he's forced to, social appropriateness. It's like expected, but no, doesn't like it.
I love hugs. I love hugs. Big hug guy. Big hug
Meg,
guy.
thanks again for your generosity. She agrees with us. She just wanted to shut down the sick rumors.
Oh, good luck to your husband, Spitfire. He's got an SSDI hearing.
Wow, I'm still. This has got to be wrapping up soon. This judge's call.
Oh, yeah. I don't know if I think we're not doing CrimeCon this year.
It'll be at the True Crime Podcast Festival.
We will indeed. Will indeed.
It has been decided, beautiful messy ball.
We got a sweet Venmo from Christina C. $10 family hug for Allie. Wow.
Oh,
thank you.
I love hugs. I just thought it was kind of cheesy.
I like cheesy shit.
I know you do.
I'm a syrupy guy,
Yeah,
I like cheese and syrup. All the sweet shit, man. See, I'm really a cupcake at heart myself, I like the sweets. I like the sweets.
Not the literal edible sweets, because he doesn't do sweets.
I try very, very diligently. I started to slip there for a hot minute in terms of, let's see. So
this was a 15-minute break. We had at least 10 minutes of bloopers.
Yeah. Okay, so I'm looking at Andrea's. She exclude evidence, witness harassment. We've done that. Exclude witness prior criminal history. We've done that. Exclude retrograde extrapolation. We've done that. Permitted demonstrative exhibit. We've done that. Exclude certain witnesses before and after testifying. We've done that. Exclude character and propensity evidence relating to Aruba. We've done that.
Well, I'm confused because didn't they file a response saying that it was relevant, or am I making that up in my head? Maybe I'm making that up in my head.
Wait, what?
I thought that the prosecution filed something saying that they were going to do that, but they responded in court that they weren't. And I think I just mixed it up because I put a comment up earlier when this was going on saying like, what he said he did name them in his witness list, but I put a comment up saying what he asked for this in his motion, meaning Brennan, but I guess he didn't. But to circle back to that, I'm concerned about the opening of the door there because I assume now the defense can never say the words, they were getting along, everything seemed good, they interacted fine. Like all that is going to open the door for, at least in Brennan's mind, I think, for them to put on, well, in Aruba, they weren't getting along. Don't you think?
Yeah. But I mean, I think they're going to avoid it like the plague.
Thanks, Jennifer, for your generosity.
So we've got permitted jury view of 34, fair view. We've done that. Permit attorney conducted panel voir dire. I think we've done that as well. Or at least it was brought up. Exclude payments relating to voir dire testimony of Arca and Dr. Russell. I think that's still pending. Exclude certain witnesses before and after testifying. That one's been done. But she's got like, so there's two of those. Andrea has exclude certain witnesses before and after testifying, which has been impounded. And then the Alberts and McCabe's. Prohibit Commonwealth from speaking with witnesses during testimony. That's a no-brainer.
Right, that was done. She entered it against both.
Exclude false testimony from Trooper Proctor regarding Yannetti meeting at school. That's still pending. Permit evidence of lack of bias of ARCA. That's still pending.
I mean,
I'm excited about that one.
Does she appear to be going in order of the numbers? Because everyone was saying
Andrea doesn't have it. She didn't go that far there. She doesn't have the numbers.
Oh, but everybody was either saying we're at 601 or they go up to 601, one or the other. I don't know.
Yeah, I don't see the particular numbers. Permit evidence of lack of bias of ARCA. Permit attorneys to state bases for objections. That one I can't wait to hear. Prohibit DA's office and MSP from contacting jurors. That's a no-brainer. I don't know that we've heard that yet. And then the Commonwealth's motions, sequester all witnesses except family members. Brennan brought it up. I don't know if that's considered dealt with. Exclude the manner of death. Admit DMV records for plate number 3GC684. Appoint a stenographer. This one's interesting. Permit an in-court identification of Karen. Permit Corey the criminal history checks of prospective jurors before swearing in.
Again, on that one, I think if they've acknowledged that they have to turn it over to the defense if they access something like that, which is, usually the primary issue is just that the prosecution can't use resources the defense doesn't have to vet jurors. Although, some people might call that all jury tampering. You're vetting jurors before you're looking at their record before. Oh, sounds like jury tampering.
It sounds like Runaway Jury, the Grisham novel. Required defense offer proof before calling DA or victim witness coordinator.
She might
be interesting. Permit use of chalks, demonstrative evidence. Now we heard about the demonstrative exhibit regarding the pieces of glass, but the Commonwealth has also filed a motion seeking to put in demonstratives. Permit in-court demonstration of Celebrite. That's still pending. Permit in-court demonstration of, oh, wait, I'm reading the same one. Admit John O'Keefe's out-of-court statements about intent to end relationship. That one's interesting.
Yeah, that one.
Exclude evidence of bad character or misconduct.
Isn't that the whole, wait, isn't that the same as, isn't that all the Aruba stuff? What, no, oh, you don't know the number.
I don't know. She didn't articulate it. Admit evidence of hospital blood draw of Karen. Exclude evidence of IA investigation, sustained findings. Permit attorney conducted panel, voir dire of jurors. So I think that one was dealt with, yeah. And then
Well,
exclude the third party culprit defense. That'll probably be the most thoroughly argued, I would imagine.
for the prosecution.
Yeah. Well, which in turn will require the defense to argue it thoroughly as well.
Right. Well, yeah, I just mean that. So that's the prosecution's biggest one. And I think the defense biggest one is the ARCA. There was another one that I thought was really big too, but I to me, it's ARCA.
See, 10 is a little bit ahead of Court TV, like 2 minutes. Like they're up and running. Should I switch it over to 10?
Well, if we're not going to miss anything.
Well, we're never going to miss anything. I'm just saying it's
All right, so go
going
ahead.
in over on 10. Okay. So I'll pull this one down.
And then just bloop us back or rewind us back to the beginning.
I will. I will indeed. Okay. All right. Share this guy. And this is right at the beginning. So we'll bloop, bloop, bloop.
If I disappear, judge let me into the Zoom meeting.
Bloop, 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 bloop. Bloop, 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 bloop.
For April 1st. The reason to
I'll hear.
Jesus, babe.
What? I went right to the beginning.
All right, so Mr. Jackson, I'll hear you on that one motion.
Thank you, Your Honor. I appreciate it. It won't take very long. I want to formalize a motion to continue the start of the trial, which is currently set for April 1st. The reason behind the motion to continue is because of some conflict that the defense has. We ordinarily would be ready to go. However, as the court knows, there's a significant appeal that's currently pending before the First Circuit based on Judge Saylor's opinion that was issued about a week ago. Given the complexion of what we're moving toward trial for, in other words, count 1, count 2, and count 3, we are mounting a defense based on those 3 counts. If the First Circuit, and I've been advised by our appellate counsel to bring this up, and it was something that he feels very strongly about, we all do.
Okay, Mr. Weinberg?
Mr. Weinberg, yes,
Okay.
Martin Weinberg. If in fact the First Circuit were to agree with our appeal and were to take some action on count 1 and count 3, for instance, either dismiss it or take some other action and remand down to the trial court for additional action, that would set the trial into upheaval. If once the jury is sworn, jeopardy attaches. And once jeopardy attaches, if there were to be some action taken on count 1 and count 3, for instance, those counts were to be dismissed, we would then be compelled and impelled to move to dismiss the entirety of the trial at that point, because it's a very different defense on count 2 than it is on count 1, 2, and 3. It's a different jury that we would pick. It's a different strategy that we would employ, and jeopardy will have attached and the entire case would go away. Ergo, we believe the best practice for the court would be to continue the trial for purposes of letting the First Circuit make its determination about count 1 and count 3, and that's the reason for the motion.
All right, do you have any timeline on that?
I wish I did. I don't. I do have a generalized understanding of some of the briefing schedule, but in terms of the court making its decision, I don't. So we expect to get our brief in today, probably by the end of the day today. I believe the Commonwealth is going, or I believe that whoever it is that is appearing for the Commonwealth, or for the court, I should say, not the Commonwealth, for the court, is due to file their responsive brief, their opposition. I think it's next week. It may be as late as the 26th, I want to say. I'm going by memory, Judge. So it's Monday? Okay. Mr. Schillinger has just indicated, I appreciate that. Did I say your name correctly? Thank you. Just indicated that it's Monday. The opposition is Monday, and then the reply brief would be 2 days hence. So the briefing is going to be done in relatively short order. The decision, that's another question.
All right, thank you very much.
Of course.
Does it make sense for me to hear from Mr. Schillinger directly, or do you want to handle this, Mr. Brennan?
Thank you.
Good afternoon. So we do need you to say your name.
Yeah, good morning, Your Honor. Caleb Schillinger.
All right, Mr. Schillinger, I have no idea how this works. So why don't you tell us?
Sure. So as Attorney Jackson mentioned, Your Honor, Judge Saylor issued his decision denying petition for habeas relief last Thursday. The defendant is pursuing a further appeal to the First Circuit. The parties have agreed to an expedited briefing schedule in front of the First Circuit. The defendant filed her brief earlier today in the First Circuit. The respondent's brief is due Monday, the 24th, and then the defendant's reply brief is due Wednesday, the 26th. As Attorney Jackson mentioned, parties are able to control that much in terms of coming up with an expedited briefing schedule. How long it would then take for the appeal to be decided after that is unknown. And the parties don't have the ability, obviously, to dictate that. I think more broadly, Your Honor, in terms of the arguments here, certainly if it were possible to have all of this resolved before moving forward, it would be ideal to know which charges are going to go forward and which are. At the same time, Commonwealth is obviously strongly opposed to moving the trial. And so, while perhaps unfair to Your Honor, if there is some intermediate ground or additional information that Your Honor would be able to provide, I think that that would be helpful. We could further discuss this issue and come back tomorrow. I would note the motion for a stay that they are going to file, they have indicated, or Attorney Weinberg has indicated to me through email, will be filed with Judge Saylor, not with the First Circuit. So there's no deadline that that motion be filed today, tomorrow, or even Thursday. So this is not a decision that needs to be made immediately, Your Honor.
Okay.
And frankly, the Commonwealth would benefit from additional time to be able to discuss with the victim's family members, and to the extent perhaps the court is able to indicate whether some amount of time is feasible given the jurors' schedules that are coming in, Your Honor's schedule. That would be helpful information to inform this as well.
All right. I appreciate that. So one of the things that we would discuss at a final pretrial conference is how long this case is expected to take. So I think the Commonwealth filed or filled out the pretrial conference report a few weeks ago and said 20 trial days, 40. How many trial days do you remember you said, Mr. Brennan? Or what do you think your Commonwealth's case will be?
I don't remember what I put specifically, but I think if we have full trial days,
Yes.
5 days a week, I expect less than a month. I'm shooting for 3.5 weeks.
Okay. Mr. Jackson?
Your Honor,
24, I'm sorry.
our defense obviously is somewhat dependent upon the Commonwealth's presentation, but
Right.
my best estimate would probably be a week and a half, 2 weeks of full trial days for the defense, if I had to sort of throw a dart.
Okay. All right. The big question is jury impanelment. Again, I alluded to all the recent publicity that I think is going to be very problematic in getting a jury. So I'll let both sides talk. That makes sense to me. Months and months ago, we got the jury commissioner's office on this to get us the amount of jurors we need starting April 1st. That process will take additional months in order to, if we change the date. So that's very problematic. So I'll hear you all tomorrow on this then.
May we address the court at sidebar on one issue before you leave the bench?
Sure.
You're muted, babe.
Oh, damn it. All right, so I just want to say that what I find that lawyer did there, he was very appropriate. There's your picture of, okay, that's someone that's sort of on the like a prosecution side of things that is very respectable and forthcoming. He spoke frankly that in a perfect world you would continue to the trial so that we know what charges are going to go forward. However, he notes that the Commonwealth is strenuously objects to it. Now, I thought that the court's comment about the recent publicity was leading me to think she might be amenable to a continuance because she thinks that's problematic. However, then she ends with, if we need to get the jury commission to round up enough jurors again for another date, that's months away. So I don't really know, which way to take it, but it seemed like her comment about the publicity was leaning towards her thinking that, yeah, maybe we do get a continuance here. And I would like to note, I believe this is just one lawyer's opinion. Once this trial starts, that completely legally moots the appeal. Right?
I mean, I think it would have to,
I mean,
right?
maybe
But
the other way
that doesn't obviate the issue moving forward. If she's convicted, I mean, it becomes a major issue as to whether or not it should have moved forward at all.
Well,
To
yeah,
me, in my opinion, as one attorney's opinion, the best practice is to wait and see what the First Circuit decides.
yes, obviously. And this lawyer agreed. The lawyer who stood up and spoke on behalf of who's representing the court or whomever he represents, it said the same thing.
All right. So we'll see everybody back here, not tomorrow, but Thursday morning at 9:00.
What?
Wow.
Time, Mr. Schillinger, to speak with maybe Mr. Weinberg or counsel.
It will. Thank you, Your Honor.
Okay, so see you Thursday. All right, thank you, everybody.
Wow.
What? Was that always the plan? A half a day?
No. Not a chance. She never would have taken the morning break if she didn't intend on proceeding further.
So maybe she is leaning towards a continuance.
I don't think she has a choice. I mean, I guess theoretically she does, but in terms of in the eyes of the law, I don't think so.
And was it supposed to be today and tomorrow, or was it always today and Thursday?
Today and tomorrow.
Well, she just said, I'll see you back here on Thursday.
Right.
I got it.
Well, sounds like a continuance to me. Wait. Rewind for that hot mic. Rewind.
What? What do you
Rewind.
want me to
for that.
do?
Rewind so we hear, so that I can shut up and we can all hear these hot mic moments.
Oh, they're hot mic moments? All right.
Yeah.
Let me bloop it back a little bit.
Okay, stop. Jesus.
Wait, we could have all
Ooh.
kinds of hot mic moments.
No, there were no hot mic moments during the sidebar.
Oh. Bloop, 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 bloop.
Okay. Eavesdropping.
Goodbye.
All right, wait. Brennan speaks.
I got it. I get too close. I don't have anything to say.
I will, I know. I know. I know.
Wait.
Oh.
Can't get better. I know, sir. That's a terrible fate.
Feel dirty.
All right, so they killed the hot mic there. That wasn't me. All right, so well, so that was underwhelming.
What
I was
the?
not aware that they had actually filed the motion to continue the trial. I wonder if it was filed this morning.
Yeah, Kaylee says Aiden's thing's coming up in 20, so I guess you have to see if it's streamable.
Yeah, Kaylee, do you know whether or not that's streamable? Huh. I don't know. True Crime Junkie says,
Well,
yeah,
what?
they said that this morning. Are you talking about that they filed that motion this morning? The motion to continue? I mean, I like when that came down and we were talking about, and I kind of articulated what they would need to show. Allie and I talked about that with relation to the federal habeas, the writ that was filed over there, and then the denial, and what they need to do in order to show that it was potentially going to stay what's happening here in the lower court, because they're on two different tracks. Like if
Wait,
if
can
it was
you
filed
find
in
it,
state court,
Stoughton Court Zoom that you used last time?
we got that after the fact because it was like a local.
Yeah, but remember, I think you called, and if you had called earlier, they would have given it to you.
I feel like I'm gonna get shut out on that because I called late.
Well,
'Cause
now you're
remember,
20 minutes early, so why don't you give it
well, they had said that the clerk was already out there, like in the courtroom, like
she
who
might not
handles
be
the.
20 minutes early right now. Yeah, I heard AJ say that's a terrible fate. I had I heard him say something about storage too, or at least I had the closed captioning up and it was picking up
All
some.
right, I'm gonna try to call the clerk's office right now.
Okay. Can you go the I was trying to look at some of your comments. We don't have any more stickers. We've been through all those. So Bob is checking to see if he can get any information on Aiden's hearing today. If we can get that streamed. But I don't know, people. It sounds like there was a dramatic change. I saw one of your comments said that they thought that she said something about what happened at sidebar changed the schedule. And the only reason I can think of that she would cancel 2 days of hearings is because she's leaning towards actually granting a continuance, which her comments about the recent publicity and that being troublesome as far as being able to find an impartial jury also lends itself to her leaning towards a new trial, which would at least be a couple of months, given the jury commission's ability to get enough people in the jury pool. So that's kind of where we stand with everything.
All right, I got it.
Oh, see?
You're muted, I think.
Oh, no, I'm not. I've been talking
Oh,
since you've been
sorry.
gone.
I turned the volume down so I could hear. Okay, so now let me try to find it.
Kind of hungry though.
Me too. All right. Okay.
Wait, are we talking about Lori Vallow Daybell's clothing? Is that what Afton's comments about? Or are we talking about something else? I'm not sure.
I think her clothes. Wait, she was wearing her
She's revealing her shoulder in court.
what right now?
I don't know. I was
I
looking
think
at
she is up today.
they aren't really altered, LOL. She wears her shirt off the shoulder.
Her
Oh,
shirt or
isn't she
her
wearing a
prison garb.
she unsnaps and like leans it out. What I was gonna say, Spitfire. It seems weird because aren't they like supposed to be more modest? But I don't know if that's a rule with LDS. Like I really don't know. I just assumed that in my mind I was thinking that it might be something. And no, it was last week that this all happened. Spitfire says it's a rule. You don't show your shoulders. Well, when she was on Dateline, she was still like, "You'll see the truth. I know the truth. I'm God." Right hand woman. So seems she still believes what she believes, but maybe that's her like way of saying, "I am not LDS. I am this new thing where I'm the head of it." And that's what beautiful messy ball saying. She's not real LDS.
Okay, I'm trying to pull up.
Well, you've got 15 minutes, so man, I'm shocked that this Zoom hasn't come about yet. Let me make sure I've got my notifications off. You could be trying to reach me.
Okay.
Oh.
It wants me to put my name. What should I put? John Q. Public.
I guess don't put attorney Robert Mata since you're not licensed there.
Right.
I don't know if you're allowed. Is there some sort of rule about streaming the stream?
A Zoom?
Do they not have a hmm.
Okay, so I've got it up. All right. All right. I mean, I got it up. So it says the host is joined. We'll let them know you're here. So that's where it's at.
That's what mine says.
Wait, for what?
For my Zoom.
Oh, yeah.
We're waiting.
Mine is the Monica Collins Zoom meeting. So, but I can see the seal of the Commonwealth of Massachusetts. So it's got to be the right place.
Well, hopefully we're not missing some sort of something. Like, I don't know.
All right, so let me see. There is one thing I want to check out. I do want to see if Oh, so Lori's shit starts at, it's late. So Kathy Russin saying the hearing started at real time at 11:25 Eastern. You should see our feed around 11:55. Okay. So they have a little bit of a delay. Okay.
All right, they're still going in that courtroom.
Where?
Mine that I'm waiting to. The host is joined. We'll let them know you're here.
Wow.
Yeah, that's what I was saying. They don't really do Zoom generally.
I mean, let's see if this gets kicked, if this trial gets continued. I mean, I think Vallow, what date is she supposed to start her trial? It's like imminent as well. There's like three big trials that I really want to cover coming up, and that's
we did a whole
Corey
series-
Richens.
We did a whole series on Vallow. I really think that that should be top of what we cover. We have, we did an entire series on it on the podcast.
I mean, I'm not doing it in lieu of Reed.
No, I'm not saying that. I'm just saying, but we could still do, the work to put it out at least in a podcast like we did last time afterwards.
Yeah, no. I mean, look, we're absolutely covering Lori Vallow's trial. I mean, she's representing herself. As
Yeah.
far as I'm concerned, that's appointment television.
I just hope a couple of months doesn't turn into like while we're preparing for our daughter's wedding, because
Of course it will. I mean, that's how life is, always. Life's never easy. Life is never easy. Let's see. Okay. I'm gonna pull up while I'm waiting I'll be watching Aiden's thing.
wait, someone said, and I wasn't.
Morning, Your Honor.
following-
Pamela Hicks and Robert Abernathy as advisory counsel for Ms. Daybell.
Go ahead and announce.
Lori Daybell.
All right, thank you. My courtroom assistant said there's some issue with advisory counsel at the table.
I apologize, Your Honor. I didn't think about the logistics, so I'll just let Ms. Daybell.
Okay.
Yeah, I was going to ask if I could have my investigator up here at the table, because if I needed to ask him something, then I need him available.
Yeah, any side can designate an investigator to sit with them through the trial and through court proceedings. So that you can have, if you can fit 3 chairs there, that's fine. Otherwise, advisory counsel could scoot her chair behind, whatever you think is logistically easier.
Appreciate it. Thank you, Your Honor.
All right. I just received word literally 2 minutes ago that we will be using Judge Kemp's courtroom, and we can use it for the entire first trial, which is in the South Court Tower, which will give us more space as needed.
Is this live?
Yes. You're welcome.
Have the parties, I had my staff drop off the proposed questionnaire on your table this morning. I know you just got it this morning. You may need some time to read through it.
How are you going to be on Zoom?
That's
with
my
your
proposed
camera off?
questionnaire. Obviously, there's maybe a lot more questions that either side would like to ask the potential jurors.
You might have to turn
follow
off
up.
your camera for us.
So this is not limiting what would be asked ultimately to the jurors. In addition to this, the questions in this questionnaire, when the potential jurors come in, I always go over the burden of proof. I go over credibility of witnesses and a little.
No, for the Zoom, I've got my camera and my mic off.
Okay.
Yeah. I put my name in there, but I didn't put.
Right. I just don't know if it'll translate over
Well, I
to your
think,
camera.
yeah, I hear what you're
If you're off
saying.
for us, it's fine.
Yeah.
A little more detail, especially as it pertains to how people perceive officer testimony. And some other areas I'll highlight. So I intend on asking more than just what's in this questionnaire, but this questionnaire is intended to get through some of the bigger issues such as pretrial publicity or opinions people may have had or exposure to the case people may have had. And then it has the questions where we may lose additional jurors on the trial schedule, and then victims of crime, views about police officer, and then if they've been charged or a close family member has been charged with a criminal offense, and to explain that. Any comments from the state?
Judge, in terms of publicity, I think my concern would be that when the jurors come in here and start hearing about the case or hearing testimony about the case, they'll hear the names Tylee and JJ, which obviously were more, there was more publicity about those than about Charles Vallow. And so I think if we really want to ensure that the jury is unbiased and has had no pretrial publicity with regards to the defendant, we're going to have to question them as to their knowledge of her other convictions out of Idaho. That was something that was just incredibly all over the media.
I agree, but I think that may happen in individual voir dire. This initial questionnaire, if they recognize the name Vallow or Daybell and they've been exposed to something in the media about it, they should tell us about what they know about it and about whether they know about that other case and whether they know about anything that happened to it about it. So I anticipate losing a number of jurors just based on that. But I agree with you. Some may say they've been exposed to it, but it wouldn't affect their ability to be fair. And in individual voir dire, we can explore those options. I don't want to necessarily taint the whole pool by saying, hey, she's got these convictions in this other state.
And Your Honor, I don't propose we talk about the convictions, but we will hear the names JJ and Tylee in this trial. So that's my concern, is if we don't raise those names, whether or not we put them in the list as people that they may hear.
What I could do is on question 15, where it lists out my name, the court staff, I need to include your name, the attorney's names, the advisory council's names in there. I'll add those. But at the bottom where it says other potential witnesses, I could do a third or another category that says other people that may be referenced but are not going to testify and list those names. That's fine. Is there any in addition to those two?
That would be the only for that. I think the other issue is, of course, the defendant's supplemental 15.2 names.
When was that filed? I haven't seen it.
I filed actually 2 motions to include them all and emailed them to your court Sunday.
Okay, maybe that's in my folder that's on my desk. Before we
Defense filed that on the 12th of March.
Okay, before we get to that, let me ask the defendant. Other comments on the proposed questionnaire and the information that we're going to put in there?
I think it's
What's that?
pretty clear.
Okay, do you have any objection to listing Tylee and JJ because they will be mentioned?
No.
Okay. All right. Let's take a look here. Let me ask the state, you have 21 witnesses listed. I need to look at the defense witnesses that were listed. And we're after jury selection. I recognize jury selection could take longer than the initial week that I've set forth, but from April 7th to May 15th, the current screening, that is 20 full days of trial and 2 half days, so essentially 21 days of trial. Do you really think we need to screen that far out? I know you're being overly cautious.
I think, especially given that I'm not positive we'll pick a jury in that first week, I think we should, Your Honor.
All right. Defense have any comment on how we're screened through May 15th?
I think it's plenty of time, Your Honor, myself.
All right, let's deal with a couple things. First, I've received the notice of compliance. That was when the defendant requested the Gilbert video. Does that apply to the second case or this case?
Your Honor, it's an incident that occurred in January. It's not really, it was disclosed because it is mentioned in the DR. The defense had filed a motion for the state to disclose that, and then had brought up again on the 11th that the state had not disclosed it, that there was some YouTube video of that. I have looked for said YouTube video. I have gone through the police report. I don't know what video she's discussing, but we're not aware of any video that hasn't been disclosed. So I'm just providing notice that disclosure is complete as to that police report that is peripherally relevant.
All right. Any comment on that?
Yes, Your Honor. For clarity, is the state proposing that there is no video or that they don't have to give it to me because it's not attached to that DR number?
I think what she said was she's not aware of what video you referenced. So as far as her knowledge, she doesn't have it and doesn't know about it.
So I should go directly to Gilbert Police Department to get it?
Well, last time you were in court, you said your investigator or someone told you about it.
A mitigator.
A mitigator.
Showed it to me.
If they have that link, why don't they just send it to the state, and that may help the state determine if that's something they've already disclosed.
I will tell you why they won't, because that is my former team and they will not do anything to help my investigator, my paralegal. They won't give us any information that they found. They won't talk to us at all because apparently there was a conflict. So they will not help us. They will not send us anything. They will not email us anything. They will not answer anything that we ask them to. So that has been the response from my former defense team.
Wow.
That's where we are.
That's outrageous.
All
They've
right.
got an obligation to her.
Do
Continue.
you know, and maybe your advisory councils can speak to this, did they turn over a file to you or did you have to start from scratch?
No, from what I understand, all they turned over was the 22 terabyte hard drive, and that is it. They didn't turn on any notes, any work product, nothing that they had done to that point. And they continue to stand by that today, even though a lot of that information I gave to them, they would not give it back to me.
Order them to turn it
All
over.
right. I'm going to make an order and it'll be in the minute entry that they turn over a copy of their entire file, including any mitigation information that was gathered to the advisory council. That makes Hicks, you look like you want to say something.
I don't know.
What's she doing?
Babe, look at your phone.
No, I'm good, Your Honor. Thank you.
All right, so I'll do a more detailed order about, they should have turned over a copy of their entire file to advisory council when they withdrew.
Why don't you try the other on another screen if that's not working.
I need to see if she'll give you the password.
You
Like
think
the
the clerk
Google.
should give it to you?
No, that was for Zoom. Like I could be in the wrong courtroom, even though I told him it was for Aiden Kearney's thing. Because she's in a Google meeting, not Zoom.
Well, if we can't get it, we can just portal everybody to,
Melanie.
yeah. Well, unless we're gonna keep watching this, I don't know. Maybe it's the same. Is it started on hers?
It says host has joined. We'll let them know you're here.
On your end or on what she's looking at?
On my end. On hers, it's still just Mel.
If you're over 50, you don't want to use traditional.
I don't know. I mean, she's talking to the people. She's probably not going to see my text right now.
I went in chat.
Oh,
All right, so I've
I
read
just
the
don't be
defendant's
concerned unless
disclosures that were filed March 6th and March 12th, as well as the state's motion to preclude. And well, let me start. Have you received any response from the defense, anyone from the defense team since you filed this on March 16th?
Your Honor, last night at 10:30 or so, defendant's investigator sent over a list of the addresses of the witnesses. I did speak with him this morning. I still am unclear if defense will be setting up those interviews or if they will be providing phone numbers to the state to set them up ourselves. As for the expert, again, last night at like 10:30 at night, defense investigator emailed the state and indicated that the defense expert would need to or wanted to obtain the physical laptops and cell phones that the police had impounded so that he could then review them, do his own sub-right or extractions. So obviously the expert hasn't even begun work, let alone they've also requested all impounded items from law enforcement. I'm unclear if they're asking for ones that were impounded in Idaho as part of their investigation or just the ones here. The statements from the investigator appears to be all of them, which would mean the state would have to request Idaho to send those to the investigator. So again, given all of those issues, I don't see how that it would be possible for the state to provide that to the expert prior to this trial beginning, let alone to get a report or an opinion prior to this trial beginning.
All right, let's set aside Dworkin for the time being. So you're
requesting.
Well, let me ask the investigator. What's your name, sir?
Jeff.
Jeff what?
White.
Okay, Mr. White, are you going to be setting up interviews for the state to interview whatever potential witnesses the defendants noticed?
I'm trying to verify, excuse me, sir. I'm trying to verify the phone numbers to be correct. I do have a few of them, but some of them I'm trying to make sure that these are the correct numbers.
Okay.
I did the searches for them, and I have to apologize. I left yesterday, and for some odd reason, my email just did not go through. So,
Your Honor, my understanding is that the state has interviewed every single person on my witness list previously. That's where I got the people from the interviews that they had from the state previously. So I understand that they're allowed to do another interview of them, but they have interviews of every single person that is on my list, with the exception of one,
Which is who?
which is Nate Eaton.
Okay. When you say the state's done the interview, do you mean police or someone from the prosecutor's office?
In discovery, I have interviews with police on every single one of the witnesses that are on my list.
Okay.
So I know that they had their addresses. I know that we were trying to get the addresses to them in the quickest way possible. And where I am at the jail, the communication is very difficult for me to get a hold of my investigator, to get a hold of my paralegal. I'm 23 hours a day locked down. If I don't have Wi-Fi, I don't have a phone. If I don't have battery, I don't have a phone. I don't have access to get to people. So I understand the time constraints, and we're doing the best that we can of getting things answered, getting things put together.
So as a threshold question, your assertion is that all these people that you've listed in your notices have relevant information for trial?
Correct.
And do you know if the police have interviewed these people?
Your Honor, the
They may be
first
referenced.
listed person is a reporter. So I'm not really sure the relevance of a reporter.
He's the only one that hasn't been. So that's what I stated.
So, Your Honor, the point is to start with, one, these people, I'm not sure all of them actually have been interviewed. Those that have would have been interviewed 5 years ago. So whether or not their addresses are correct, unclear. It's not the state's responsibility for the defendant to do the defendant's work and find these people. I have an absolute right to do interviews just as the defendant does. So in terms of the witnesses, I think that most of them, as best I can guess, would be character evidence, which would be improper under 405. So depending on what they say, then I need to file motions to preclude or motions in limine for any or all of these witnesses.
All right, so it's premature to address these today. The state's going to have to interview them and find out if, in their opinion, they have relevant information or not. And then if there's a dispute as to whether or not they'd be called, I'll have to deal with that as it comes up. But if they're unable to be located or interviewed, obviously they won't be called at trial. Mr. Dworkin, if you want him to.
You're muted. I sent you what Mel sent me.
There's two things up. He's
Did
getting
you
a
hear me,
rate.
Mel?
Huh?
Did you hear me?
I did, but there's two things up. There's the arraignment on the new charge, but I think there's also the motion to revoke bail and throw his ass in jail.
Well, then I'm sure they're going to appear on the same, in the same courtroom at the same time on the same stream.
I think Google Meet is audio only.
All right. Well, why don't you see if it's happening? Like, open up both, and if the Zoom doesn't click, then you can play the other.
Okay.
Wow, this is, geez, this is a long court morning. I don't know what's going on over there.
Do extractions, you're not ready for trial. So in order for him to do the work that he's requesting, getting copies of a laptop or a cell phone or whatever the case may be, that's going to take him time to extract and analyze and then prepare a report, months maybe.
I understand that, Your Honor, and I'm hoping he can do it in an expedited manner. I requested him from OPDS on January 14th. He got approved on March 7th.
Well,
from OPDS.
You're the one pressing for your speedy trial, so you kind of have to make a decision on.
Right, lady.
We're set for trial. You want to go to trial, or you want to have him do that work that you want? Because I don't think both are going to happen.
Right.
Even if you got the laptops today, generally those types of things can take weeks, even months to analyze and prepare a report on.
I understand that. And I also understand that I've only been given 10 hours for him from OPDS, right? So if he could spend 10 hours this week getting them ready, then he can give us a report with the best that he can do.
Well, the report's already late technically, but if it
Answer
were
Teddy's
allowed,
question.
first of all, it's going to take time to coordinate him getting let's start here. Specifically, what are you requesting? Because the state wasn't clear whether you were requesting items here impounded by a particular police department or items that may be impounded in Idaho.
Well, I'm sure that my investigator would like to have all of those things done, and I realize that we're on a time constraint, and I would be only concerned with one item, which is at Chandler Police Department, which was Charles, my husband's phone, Charles Vallow's phone. And I would like a copy of the extraction that they took from it. The digital forensic extraction from Chandler Police could be given to him immediately. That would be very helpful.
Wasn't that already disclosed?
Yes, Your Honor.
Was that part of the initial terabyte?
Yes.
Will identify where.
Yeah.
Everything that I have is on a 22 terabyte. So if
Hard
drive. So if I give that away, I can't do my work.
Well, can't you make copies of files out of it?
22 terabytes.
I understand that.
Okay.
So what's your proposal?
I'll take it up.
I mean,
He's like, I'll.
if you have all that information in a file, I'm not saying you have to copy the whole 22 terabytes, but there's a file in there somewhere that's the Cellbrite extraction already for that requested item that's been in defense possession for however long now.
Why don't you just suggest they resend just
So,
that document?
I'm happy to make an order, but again, if he's not done with that information you want, are you still wanting to proceed to trial at the end of this month?
Yes, Your Honor.
Okay.
Oh my gosh. She's an idiot. She's an idiot.
Duh.
Yeah, I would ask leave that depending on what Mr. Dorkin says, that
Well,
would
it
be
could still be precluded because
Right.
depending on what his opinion is, first of all, it's
late.
It's late under the rules of evidence and rules of disclosure. And secondly, depending on what he
God
says, the
tell
state
her
would
that?
have to have an opportunity to consult with an expert as well. So even if he got something done, it could still be precluded, but I'll give him the opportunity to do whatever it is that you think he needs to do to analyze that. But that information's been in defense possession for months, if not over a year.
more than a year, Your Honor.
And he was just approved by OPDS last week, Your Honor.
I thought you said he was approved. You applied in January.
I applied for him in January and last Friday, he got approved.
Again, this is one of those things where you have to weigh your options on whether it's worth it to get a continuance so you can have your defense
Ready,
do
idiot.
the work that you want done on your defense. But if you're telling me you don't want to do that,
I would like to do that, but my situation in my housing department precludes me from doing that.
from asking for a continuance,
No, from getting things done in an effective and quick manner.
all right, well, so you're telling me you don't want a continuance because any information he has at this point could be precluded as being untimely.
I understand that is the rule, and I understand how unfair and prejudicial that would be to me.
So then ask for a continuance. That's your remedy. Well,
That's what the judge tried to tell her.
So I guess I'm gonna have to cross the bridge on whether these notice defense witnesses are even able to be located and interviewed before I make a decision on whether they have relevant information and can be called at trial.
Obviously, Your Honor, we have a little over a week to try to interview these people, so I will
understand.
file something at the end of next week indicating who I've been able to reach and interview and ask to preclude everyone else.
All right.
They also obviously ask to preclude them regardless,
Right.
based upon what they may say.
All right. What else do we need to address today then? from
Your Honor,
the
the only other motion that we did not address last week was the state 609 motion. I presume the defendant will likely testify, so I don't know if we wanted to address that now.
Are you prepared to address that now?
No.
I generally will, I guess I'll advise the defendant now that if you choose to testify, it's likely that the jury would hear about the convictions. But at your request, they could be sanitized, meaning that they would only hear about the fact that you have convictions as opposed to what the nature of the conviction are. But that would be up to you whether you want that information out or not. And then the jury would receive a limiting instruction that the existence of those convictions is only to be used for the purposes of determining credibility. So you should be aware of that when you make a decision on whether you want to testify or not. Oh, if you do want to testify, it will be question and answer, meaning you need to write out all your questions that you want to be asked and have one of your advisory counsels ask those questions to you when you're on the witness stand.
Right.
Okay, so you can't take the witness stand and just give a narrative. It'll be question and answer.
So am I supposed to reply to the 609? Is that what you're saying? And ask for it to be sanitized if I want that?
We can talk about that when we actually have a 609 hearing, but yeah, you can make that request orally. You don't have to do a written response. I indicated last time for your opening statement and closing argument and questioning witnesses that you'll pretty much be limited to the podium. We'll be in a different courtroom apparently for trial, but it'll be set up very similarly. Either your investigator or one of your advisory counsels will approach witnesses with exhibits if you have to show a witness an exhibit. So I'll have to do the same limitations on the state. The state would be confined pretty much to the area of the podium, and the state would have someone assist in approaching witnesses with exhibits and that sort of thing.
All right.
All right.
I have some motions that I'd like to file. I've had a really hard time getting my
copies
paralegals
for the
very
state.
busy. I don't have copies.
All right, we'll make copies and give them to the state, and then we'll file them, and depending on what they are, I'll rule on them as the response and replies come in, or we may have to address them depending on what they are. So plan on that questionnaire going out. I think we said next Thursday, the 20th, will be sent out to potential jurors for the first batch of jurors, and then the responses would be cut off on the 26th.
Judge is going to be sent out Monday the 24th and will end on Monday the 27th.
All right. And then I'll meet with the parties on the 31st to go over those remote responses. So that'll be the 31st at 10:30 a.m. Then again, I'll just reiterate on April 1. Are we having we're not having walk-ins, Izzy, until the 1st?
Well, if they both go, we might
And then
need
on
to
the
have
1st, we will
live streams.
meet again. And for the rest of that week, we'll likely be meeting at 10:30 and continuing with jury selection every day until we get enough jurors. Hopefully we get enough the first week. If we have to, we'll go into the second week.
I mean, here the issue for Vallow is that she's pushing the trial date because of her speedy trial demand, and the judge tried to tell her in 15 different ways
Judge,
that I'll grant a
I know that I've
continuance,
given
but
you
you
a
got to
date
waive
that I
your
was going to
speedy
need to be
demand.
dark on. I'm going to put out there, since I obviously don't know when we will get the jury picked. I do have some witnesses that are flying in, so I may have some days where I may need to end a little early or whatnot to try to accommodate some witness schedules. But I'll keep the court updated once we get a jury picked.
I think we'll have a good idea by about day 2 of jury selection, whether we're going to need to go into the next week or not. That reminds me, though, is I would like the parties to plan on we're gonna have a much better idea after about the second week of trial and the first trial, how the second trial will unfold as far as how many jurors we might need, but I would like the parties to plan on doing another remote questionnaire with a much larger pool for the second trial and meeting on Friday, May 30th. I'm just giving you a heads up as far as this is concerned. And then for scheduling purposes, so everyone knows, I'm planning on probably going Monday through Friday of the week of June 2nd, as well as Monday through Friday, the week of June 9th, to try to get as much done as we can. And then there's going to be some dark days there toward the end of June, but we need to get it done by July 4th.
Your Honor, when are you planning on starting that trial?
So jury selection would be the starting May 30th. All right, anything else from the state for today? If you want to stick around, we'll get you copies of those motions.
I do. Your Honor, I guess the only other thing is for the questionnaire, are we going to put in the defendant's 15.2 witness list?
I'll put in those names preliminarily. It doesn't hurt, just in case anyone is called from that list. And if anyone knows any of those people, I will put that in actually. Anything else from the defense?
So I'm unclear on where we stand with the video that I requested.
The state says they don't know what video you're talking about. They've disclosed everything they have. So I'm going to make an order to your prior team to give you whatever that is. If you have a link in that information, you can forward it to the state so the state can see if that's something they've already disclosed or if that's something Gilbert didn't give them, or on the other hand, since it was told you secondhand or showed you secondhand, whether it's something different than what you thought it was. I don't know. So I'll make an order that they hand over all those things to you, so maybe you can figure that out. But at this point, the state says they've disclosed everything that they have and everything that they're aware of.
And in that order, they'll give it to my advisory council, or who?
Who do you want me to? I was going to say give it to your advisory council. Do you want a more narrowed order? Maybe any mitigation work that was collected, or do you want a broad order that's basically everything in their possession?
Well, it would be nice if they could turn over everything in their possession that we worked on.
I was just thinking
together.
it would be easier for you maybe to find that needle in a haystack if it was a more narrow order.
Well, she knows what the link is, and she could just give it to us, and we asked for her to do that, and
What's that?
the attorney said, no, she can't do that. She can't give you any.
What's that mitigator's name?
My mitigator's name, Pamela.
On your prior.
Pamela Kearney.
Do you know how do you spell Kearney?
Cerny.
All right, I'll make a specific reference to that.
And do we need an order, Your Honor, to pick up my husband's phone at Chandler Police so that Lonnie can do the extraction?
Well, you already have that extraction in your discovery. What's the state's position on Lonnie Dworkin meeting someone at, you said Chandler, right? Chandler
Yes, at
Police
Chandler Police
Department to do another extraction.
Your Honor, obviously the state and defense have always had stipulations so that should something happen to the device while it's in the possession of Mr. Dworkin, that there are now no issues with chain of custody or anything else. So the state would have to draw up a release, have that scheduled on who it's going to be picking it up, have the defendant sign that release indicating that she understands that should anything happen to that she waives those rights to claim those things. So
I think what I was asking was, does Mr. Dworkin have the ability to just do the extraction on site?
on site where? At Chandler?
At Chandler.
I don't think the police departments allow anyone to go in there and conduct their work in the police department.
Okay. All right, so to maintain the chain of custody, the state can draw up an agreement And if the defendant signs that agreement, then Mr. Dworkin could pick up that phone.
That's perfect. Logistically, how's that gonna happen?
She's gonna forward that to your investigator, and I guess he'll have to come down and have you sign it.
Okay.
All right. Be at recess.
Okay. So we'll pull that down. Where'd Allie go? Maybe her Zoom finally started. Okay, so let me see if there's a way. All right, so I've got Mel's channel on. Aiden's thing has not started yet. So at least as far as we can tell, unless they're just not letting us in. So she definitely has this Monica Collins Zoom meeting up on hers as well. So, because I was having a really hard time figuring out how she got into Google Meet because she used a phone number. So I don't know how the hell that works with my computer. Like I was putting in a Zoom, or I was putting in the Meet code that Melanie texted us. That wasn't working. But I was on Melanie's channel when she was dialing in. I don't know. I don't know if somehow she had her phone. Like she's clearly more of a tech wizard than I am. Because I just could not figure it out. I was gonna ask Allie. I'm like, yo, can you maybe help me? Let me see if I can pull this up. So I keep hearing rumblings that this hearing's not taking place until 2 Eastern Daylight Time. So I don't know. So that's what I've got. You can see it's spinning up there. So this is the Zoom that the clerk gave me for Aiden's thing. And it's the same thing that Melanie's got up. So, but I like, to be honest, I'm a little confused about what's going on and who's doing what. It sounds like Brennan might be going over there, maybe on this motion to revoke bond. So, because remember, he is on bond for the pending charges. He was recently charged again with another charge of intimidating a witness. And when that happens, when you're out on bond with your case pending, if you do something that the judge construes as violating the law, they then can revoke your bond, which means that you have to wait in jail if the judge so decides to revoke your bond. I mean, theoretically, maybe you could put him on house arrest. Oh, snap. Something just happened with Melanie's thing. I don't know what just happened. It's weird. Oh, never mind. It was my computer. It was my tech wizardry. So yeah, I mean, we'll have to wait and find out. Because if they do that, if they revoke his bond and he's not willing to give him home detention, he might get popped in there, have to sit in jail, which it's rough. You know, in his case, they still have it's much like over here, even though it's at the appellate stage in the federal level, the motion to dismiss. Now he's trying to he's got a motion to dismiss pending the judge's decision on that case over there. So that's still out there. Still waiting. You know, those take a while for judges to kind of get through because they do want to make findings. They need to make findings, especially if they're of the mindset that they're either going to dismiss it or not. So you know, they're just not going to do a gall and just be like dismissed without hearing, or, you know, there was a hearing. So he'll make findings. So that's got to get drafted up, whether it's by him or a law clerk, which he then. Yeah. So Aiden thing, I wish we had some boots on the ground over there. We got any boots on the ground over there? All right. Oh, what's this? Wait, something's happening. Okay. Join an audio, but
I was.
I don't even know if it's the right courtroom. I see Mel's in there, I'm in there.
Dad had to go to the bathroom as soon as I got called on Zoom call.
Of course he did. His timing's impeccable.
So he made it in. I was like, well, you probably got like a minute before he calls me. He made it in. And then he's trying to open the door. Like, it's like, can I come out? And you can't even, I can't hit mute. Only the judge can hit mute. So I'm like waving my hand, like trying to say, no.
You got people sit over here as well, okay? I don't want anybody standing, so try to make some room for everybody, please.
Can you guys hear that at least?
I can hear it.
You have to squeeze in.
Or we
Don't want anyone standing.
ticker down.
I'm trying to get, I want to get on this one. Because there's the one Zoom of the actual court. Like, I don't know why it has this one as the primary one that we're seeing.
So you can pin it, Bay. Right now it's probably set to whoever's talking.
Okay, I'm going to add that. Oh, God damn it, you're brilliant.
But you're going to want to unpin that once it gets started so that it will rotate, you know, from person to person. Try. There you go.
Look at that. That was some like tech wizardry. My tech wizardry's ahead of Melanie's tech wizardry.
So is this the Zoom that the clerk gave you, or you had to use what
Yeah.
Melanie gave you?
No, this is the one the clerk gave me. She's got this up too on hers. I'm watching her live as well. She doesn't have this fantastic full screen up yet. She doesn't know the unpin trick that you just told me, or to pin it. You should text her to pin it.
Oh wait, I gotta put.
I'm gonna tell her.
I'll text her.
I had to. I super chatted her to look at her phone to read her text.
She might have sent it already to me by then.
All right, she figured it out.
Oh. I was about to text her, but I had to click save on. I hadn't saved my next court date. on Tuesday. I got to go from Will to Winnebago.
Next week?
No, next month.
Oh,
Will in the morning, Winnebago in the afternoon. Oh,
yikes.
actually, my will might be, it says in person. Hey, his in person. Next one's got to be in. The judge doesn't do Zoom. He wasn't happy about having done it this time. He approved it though.
Yeah.
So, can you still see at the top of your screen the other windows that you're not pinned?
No.
All right.
Because once it shifts the view, you might want to.
Court in session, you may be seated. Good afternoon, Your Honor. In the matter of Aiden Kearney,
Try unpinning now and see what the view is.
Okay.
Speaker view. Perfect.
I'm going to remove the pin then.
Mr. Kearney,
You did.
before the court on docket 25 CR 225, being charged with one count of witness.
It'll go away,
intimidation
just
of a
leave it.
witness or a police
Leave
court
it.
official on March 5th, 2025 in the town of Canton. The defendant has filed a motion to dismiss. Commonwealth filed a motion to revoke the
Okay.
defendant's bail, and there is an email for you.
I put the pin back on. It wasn't doing anything.
It will when she's done talking.
Just give me one moment to look at the email. And just to be clear for the record, there was a video that both counsel submitted. I've marked it as Exhibit 1. It's in the court's file. I viewed that prior to coming out.
Thank you, Your Honor. No objection to
Thank
that.
you.
Timothy Bradle on behalf
Babe,
of Mr.
put
Carney.
it
Good
in speaker
afternoon.
view so we can see the
Attorney
lawyer when
Bradle.
he speaks.
Good afternoon, Your Honor. I'm Robert Cosgrove, Special Assistant
Oh,
District Attorney
okay.
for the Commonwealth. Good
Never
afternoon.
mind. He's
I'm
on.
keeping it on this view.
Yeah, if he's not showing his face, then
That's
yeah.
relative to the bail revocation issue, Your Honor.
Isn't Aiden there?
Yeah, they're in court, so they're not
Okay.
going to get a view.
No, they usually do. I see the other, whatever.
Stu, do you want to hear the motion to dismiss prior?
In light of the Commonwealth's position, I would certainly ask for that, Your Honor. Thank
All
you.
right, I'll hear you.
Thank you very much, Your Honor. Your Honor, the Stoughton Court, I just want to start with this court. The Stoughton Court has a interesting relationship with the witness intimidation statute and me and Mr. Kearney and some other clients I've had. There's been about 5 or 6 cases that have come through here where this exact type of conduct at issue in this case has been not acted upon by the court. Judge Walsh in this court in a case called Commonwealth versus Richard Schiffer, same kind of thing. This Canton police did a 37-page investigation of Mr. Schiffer leaving rubber ducks around Canton with political messages on them relative to another prosecution that you're probably aware of, the Karen Reed murder case. And the Judge Walsh dismissed it at arraignment for violating the First Amendment. Assistant Clerk James Flanagan in this court, I represented four women that were accused of the similar things, sending out messages, commenting on the case directly to witnesses, leaving ducks around Canton. All 4 of them were not acted upon. There was another instance of what's called the Canton 9, Your Honor. People that were demonstrating in the middle of Canton. There were 9 people were charged with witness intimidation and other related charges, all dismissed. So the Commonwealth just doesn't get it, Your Honor. We need a seminar on the First Amendment. Here we go again. We have Mr. Kearney in this case, Your Honor, is exactly where he's absolutely entitled to be. There's no stay-away orders in place. There's no restraining orders. There's nothing that prohibits Mr. Kearney from going down that street. He went to Jeff McCarthy's for a meal, and he walked by the complainant Albert's Pizza Place in Canton. He looked inside. He saw a camera inside, and looked at it and looked in there and spoke to no one, to a glass window at 9:30, 10:30 at night, 2 occasions before and after. So he had every right to say what he did.
The only involvement that the court needs to be concerned about would be if he uttered threats or fighting words. That's already been roundly established in my 14-page memorandum, Your Honor. I'm not going to belabor it. I know you've read it. I appreciate you having that. And the cases are all there, absolutely spot on point, Your Honor. All these issues have been covered. There's no threats here. There's no fighting words. There's nothing that is criminally actionable that happened whatsoever. Because the Commonwealth doesn't like it, they want to use it as probably their 10th or 11th, what I hope will be their failed excuse to try to go after Mr. Kearney. Not because he's a danger to anyone, not because he's doing anything criminal, but to silence his speech. That's what this is about. And that's why I've been so happy to always be coming to the Stoughton Court on these cases, because the Stoughton Court gets it. The Stoughton Court looks at these cases and says, this is not a crime. Stoughton Court has, with an unblemished record, Your Honor, upheld the First Amendment. And I hope that in this case, which is just as weak, if not weaker, than all the other things they're trying to say are felonious activity, I hope the court will address it appropriately. And I know the court will. So in terms of whether the court ought to, whether the Commonwealth rather, ought to be permitted to bring this forward, there's absolutely no basis. Everything that Mr. Kearney said is not actionable. There's no threat. There's no fighting words. The only reason, Your Honor, that this has been given life, Your Honor, is because of the complainant's illegal wiretapping. He had a camera inside the store that apparently picked up sound. And also, Your Honor, there was a camera in the top right outside on the street that picked up the sound of every person walking by. So there's no warning signs. There's no notice that someone is being intercepted under 272 Section 99, the wiretap statute. He's been committing a felony every time someone's voice gets picked up on the street. And there's no warnings about it whatsoever. So Mr. Kearney doesn't have to, when he's clowning around outside the store where he's absolutely allowed to be. And incidentally, Judge, the last time we were all together in Superior Court, Mr. Kearney agreed under Section 87 to a stay-away order on this situation. So that speaks well of his understanding that he's not going to risk any other problems or issues. So that's an aside, if I may, Your Honor, that this has been agreed to when the government brought the bail request that they told me they were going to be renewing here. We agreed to it. So I want the court to be aware of that as well. But in terms of this speech, Your Honor, the only reason that the complainant heard this speech is because he was illegally wiretapping Mr. Kearney. This never would have come to life. He never intended it to come to life. He didn't know it was going to come to life. And the next thing you know, he's being wiretapped by the complainant, who now wants to use his illegal behavior to try to get Mr. Kearney locked up. The whole thing is a complete absurdity, Your Honor. Mr. Kearney is talking for the benefit of his friends to a window on a almost empty street at 10:30 at night. There's no danger whatsoever. There's no basis to plug that conduct into the many elements of witness intimidation to try to concoct some bizarre alchemy, some felonious charge that would somehow get past the First Amendment for all the reasons that I stated in my motion, Your Honor. So that's what I have for the court. I appreciate you reading my motion, and I'm asking for about the 10th or 11th time that the court dismiss these charges. Thank you.
Now, is that guy on camera, babe? Check.
No one's on camera.
Just when he starts talking.
Thank you, Your Honor.
Oh. Okay.
Mr. Albert, as is his son, is a witness in the Karen Reed case. Mr. Kearney has been in the process of conducting a campaign against virtually every Commonwealth witness in the Karen Reed case, using his various media outlets. What I would like to do is briefly read the court some excerpts so I can put them on record from the police report of Lieutenant Tully,
Some of it characterizes the video that Your Honor has already viewed, but it's also illuminative of the reaction of the Alberts upon viewing that video. After I do that, Your Honor, I will proceed to address the contentions that have just been raised by Mr. Bradel. Lieutenant Tully indicates that on March 5th, he spoke with Chris Albert, and he mentions that the Reed defense attorneys have alleged a massive conspiracy to frame Reed and have stated in written pleadings in an open court that Colin Albert, who is Chris Albert's son, is responsible for the death of John O'Keefe, and that Chris Albert has aided in the conspiracy. Beginning in April of 2023, Kearney began posting articles to his website and social media accounts where he adopts the defense allegations as true and makes personal attacks on civilian witnesses, members of their family, and their friends. He authors and publishes a blog on the website Turtle Boy Daily News. The website has a series of articles entitled Canton Cover-Up. He goes on to describe arresting Mr. Kearney on charges he was later indicted with. Those indictments are still pending in Norfolk Superior Court. Chris and Colin Albert are named victims in those open cases. Chris Albert forwarded to Lieutenant Tully 2 videos from March 4th of 2025. Subsequent to that, Your Honor, the district attorney's office merged those 2 videos, so the video that you saw shows the 2 of them playing simultaneously. They're 2 different cameras showing the same events. The sound has also been enhanced, but otherwise the videos are in no way changed.
Illegal.
As described by Lieutenant Tully, the video depicts Kearney walking down the sidewalk from the direction of C.F. McCarthy's, which is a bar/restaurant located next to D&E Pizza at 614 Washington Street in Canton. The group is seen leaving McCarthy's that joins Kearney. Kearney stops in front of D&E and places his face next to the glass window. Interior camera catches him standing close to the glass, staring at the camera for approximately 25 seconds. Male with the group that exited joins Kearney. Kearney then begins speaking into the interior camera for over 1 minute.
We know all
Audio is captured by an exterior camera. The sound of the occasional passing motor vehicle obscures the audio. Lieutenant Tully stated that he could discern the following statements made by Mr. Kearney. "Hi, Chris. What have you done?" "Murdered," then goes inaudible. "Misses you. Wishes he was alive today. He would be." "Why did you do that, Chris?" "Chris, why did you tell the jury that you got home?" "Why did you say you went upstairs and then waited 15 minutes?" "And Colin came home. Colin didn't make it home until at least 12:45. Chris, it was Colin, Chris. I just want to know. I just want to know why Colin took so long to get to your house. Why, Chris? Please tell me why. Colin did it. You can tell me. You can tell me, Chris. I know you didn't do it. I don't want to scare you. Tell Jill to keep their hands to herself, too." The statements made by Kearney and his conduct of standing outside D&E Pizza is similar to the conduct that was the basis for his prior indictments. Kearney directed his statements into a camera that he knew would at least be seen by Chris Albert, a named victim in the pending witness intimidation case and a witness in Commonwealth versus Reed. When Chris saw the video shortly after the incident, he became upset. He stated he is upset for his son Colin and the possibility that Kearney would continue to come to the restaurant and confront him or his son, which I would add, as he has done in the past. Subsequent to that, and as Mr. Bradel indicated I brought this conduct to the attention of the Superior Court at a hearing on Mr. Bradel's motion to dismiss about 2 weeks ago. Lieutenant Tully received another video, and I want to add, with respect to the first one, that what brought this Chris Albert's attention was that on March 4th, he received a phone call from his son, Colin, who was working at a pizza restaurant that he owned. Colin learned that Kearney was having dinner at the restaurant next door. He was very unnerved and anxious about Kearney being next door while Colin was working. Chris, who was attending a Canton Select Board meeting, traveled to D&E following the meeting, and they closed the pizza restaurant at 9:30 and went home. He then received an alert on his cell phone from the camera system at D&E Pizza, accessed the video recordings, which Your Honor has viewed. Chris was very upset about Kearney's statements into the video camera, especially given previous incidents where Kearney picketed outside the restaurant during business hours. He's also very concerned Kearney will continue to be outside the restaurant and will confront him, members of his family, or patrons in a similar manner Kearney has done in the past. And I think the second video that Your Honor saw was a later discovered video indicating that Mr. Kearney had been present earlier in the evening. Now, with respect to the motion to dismiss, if I can turn to that in this point. I don't have a quarrel generally with the proposition the First Amendment protects a wide range of free speech, and that the usual remedy for a victim of defamation is on the civil side of things and not on the criminal side. But what the defendant ignores, and I believe Mr. Bradel ignores, is the courts from the U.S. Supreme Court on down have said, where the Commonwealth or the state has a compelling interest, it can craft an appropriate limited criminal sanction regulating speech in a reasonable fashion as to time, place, and manner.
Wrong.
Now, there are a number of examples of that in our law, Your Honor. I'm sure Your Honor has probably had occasion to issue 209A.
He has an unblemished record,
orders.
sir. The
typical feature of those orders is that the 209A recipient is to have no contact.
There was no
direct
order
or
in place, sir.
Indirect. with the
Sorry.
victim.
There was no such order in place,
And
sir.
the cases have uniformly supported that when that contact is made, whether it's a phone call, we might otherwise say is freedom of speech, even if it's an innocuous subject matter, even if the
How does he think
defendant
it's comparable?
sends the recipient of the 209A order, the protected person in the 209A
I don't know what
order,
he's
a
talking about.
bouquet
That was
of
after the
flowers.
fact.
That is a violation that may be criminally punished. We also know that laws protecting courthouses and prohibiting disruptions outside of courthouses are also constitutional and legal.
There's a balancing test.
We also
sir.
know that judges routinely impose conditions of probation requiring no contact, stay away, not travel in a certain area, those orders, too, Your Honor, arguably impinge on rights of free association and speech, yet all of those are constitutional and have been upheld. With respect to the victim witness intimidation statute, which is at issue here, the legislature has imposed a very limited restriction on speech. And the limitation comes in the form of two elements. One is the protected class is not the public generally. They are left to their civil remedy. But the protected class are witnesses in a criminal case. The second reasonable limitation, the second restriction, Your Honor, is that to prove witness intimidation,
Oh my God.
the
There's
Commonwealth
violation
must
of the
prove
law.
beyond a reasonable doubt the specific intent of the defendant's conduct was to intimidate the witness. Now,
He said he was at least agreed to that he was going to be seen. What was
it
intimidating
seems
about?
to me, Your Honor, that one of two things has to be true.
Let's hear it. What
Either
you got, buddy?
209A orders, probation conditions,
I hope
and
this
laws
judge, like,
against disrupting
literally
court proceedings
gavels him.
are unconstitutional
Oh,
under the First Amendment, possibly other amendments as well,
possibly. Possibly.
as is the witness intimidation statute. Or the witness intimidation statute constitutes a reasonable limitation by the legislature in service of a compelling state interest, which is the integrity of the criminal justice system.
As applied, unconstitutional.
Mr. Kearney
as
has
applied.
effectively conducted a campaign against virtually every Commonwealth witness in this case. It has been unrelenting. I don't know if I am to go back to those witnesses, those victims, and say, well, you have a civil remedy, go over to civil court, file a lawsuit, hire an attorney if you can find one, retain him for $1,000 or $20,000 or $50,000, or maybe you can get a contingency fee. And then after depositions and motions and interrogatories and so forth, 3 or 4 years from now, you might recover a nice civil judgment. But in the meantime, every day you are going to be hammered and intimidated, and there is nothing the criminal justice system can do about it. Those seem to me, Your Honor, to be the alternatives. And based on that, Your Honor, I would ask you to deny the motion to dismiss. I have a couple of answers.
He's like, I don't
Briefly.
know.
Judge, page 5 of my brief, U.S. v. Alvarez, sets out the entire field of where the government can intrude on the First Amendment. There's no provision for reasonable restrictions on this or that. There's no opportunity for the Commonwealth of Massachusetts to try to criminalize civil tort laws somehow.
I don't think that's what Attorney Cosgrove was saying. I think what he was saying is that it's a different class than the general public. And while I agree with your sentiments regarding Alvarez and the general public, what we're talking about is a more restricted class, specifically witnesses in a criminal proceeding or possible witnesses in a criminal proceeding, and in this case, a known witness in a criminal proceeding.
There's one other issue there, though, which is that there's no stay away order. There's not even a stay away order.
And that's
That's the determining factor.
well, that may be the determining factor at the end of the day with respect to a defense at trial, or perhaps whether or not his conduct was harassing as the statute anticipates. But the standard of proof that I need to apply here is whether or not there's probable cause that he's violated the statute. And the statute that reads that did mislead, intimidate, or harass another person who was a witness or potential witness.
Yeah.
And
Can I address that point?
sure.
Thank you, I appreciate
I mean, the
it.
judge's making a point here.
Harassment is defined, and harassment is limited by O'Brien v. Borowski.
There you go.
True threats, fighting words. So manifestly, these videos have no threats, no fighting words.
Wait, so take the sound out of it. The video that I watched that you both submitted by agreement begins with him just staring directly in the camera. He's not passing by. He walks to the camera and then he walks back in the direction from whence he came. And he's staring at the camera for a prolonged period of time before another individual comes up and starts speaking to him. And that's when the words happen. And whether or not you have a Fifth Amendment claim for the witness at trial because of wiretapping or not, it's not what's before me. What's before me is whether or not there's probable cause to support the charge. And after considering your motion and the depths of research you've done on the First Amendment and considering the standard of proof that I need to apply here, which is probable cause, I'm going to deny the motion to dismiss.
Wow.
No, my objection. Thank you very much.
Your objection is certainly noted.
And he was going based on just the looking into the camera.
Yeah.
Oh, we're going to break all this down for you guys in a minute. Let's just see if the judge has got any more to say.
Well, is the Commonwealth going to ask to revoke his bail?
Commonwealth, I hear you on your motion
There you
and any
go.
request for bail.
Thank you, Your Honor. With request to bail on this case, Your Honor.
Does Mr. Kearney be arraigned first?
He was arraigned. Right, you entered pleas of not guilty. He was arraigned. I mean, I would have stricken the arraignment had I allowed the motion to dismiss. That's why I wanted to address it first.
With respect to the question of bail, Your Honor, I'm going to request that the court set bail in the amount of $5,000 cash in the instant case, and I'm going to ask the court to impose a stay-away order
I thought he's already subject to one.
from Mr. Albert and any member of his family. And I'm going to ask that that order, I should say a no contact order, direct or indirect. And I'm going to ask as well that the court order that Mr. Kearney remain away from the pizza shop, from the home of any of the Alberts, and from any place of work, the Alberts, and that he maintain a distance of at least 100 yards from those locations. The order in the Superior Court, I will say, is a little broader. The order entered the other day, and it now extends to all of the witnesses in this case. But since only only the Alberts are implicated in the case before Your Honor, I think it's proper to limit the order here to them.
In the motion to revoke?
Yes. With respect to the motion to revoke, Your Honor, I think it's important to consider that this is the same conduct, or another species of the same conduct, for which indictments are pending against the defendant in the Superior Court. There are indictments for intimidation of a witness with respect to Brian Albert, with respect to Christopher Albert, and with respect to Roland Albert. These indictments represent a series of conduct by Mr. Kearney, including showing up at selectmen's meetings where Chris Albert is a selectman in one meeting.
Freedom of association, sir.
Chris Albert testified before the grand jury that at that meeting, Mr. Kearney came within 2 feet of his ear, holding negative signs about him, stuck his middle finger in his face, captured on camera for his viewers.
That might be a little much.
And as he left the building, he and a mob of about 15 or 20 people pursued him to his car, screaming at him, calling him and his son a murderer. When Chris reached his car, Kearney and his followers surrounded it and prevented him from leaving until the police were able to back up the crowd. He's encouraged people to harass Mr. Albert at his business. He's run videos attacking members of the Albert family, including Mr. Albert's wife. I'll read you some of the titles of those, Your Honor, that were played for the grand jury. Episode 590, Call to Julie Albert. Julie Albert, I might add, has nothing to do with the Reed case, but in Mr. Kearney's view, she's a fair target because she's related to somebody who is. Therefore, to attack her is another way of putting pressure on and intimidating a witness. Episode 598, Life as Normal is Over. Time to hit the gas. No right for Chris Albert to live peacefully. Albert should be afraid. Kearney outside
That's
D&E
nothing.
Pizza. And those, Your Honor, were examples of some of Mr. Kearney's shows prior to the indictment. Indictment has not fazed him, Your Honor. He's continued to harass the Alberts and the other witnesses. When you look at the videos in this case, if you looked at them in isolation, if I looked at them in isolation as a prosecutor, I might think, oh, well, there's maybe a few sheets to the wind after his visit next door. He's clowning around. It's fairly innocuous, repulsive, but innocuous. But understandably, the Alberts and the Commonwealth look at them in the context of the prior conduct. This conduct has continued since his indictment, not only with respect to the Alberts, but as to the other witnesses. If Your Honor has viewed the exhibit submitted by Mr. Bradel, I had some discussion with him about what I would be asking for today. And I didn't indicate, quite candidly, that I was going to move to revoke Mr. Kearney's bail. That was not my original intention. But I did say, subject to, I don't recall the exact language, but Your Honor has it in front of him, subject to what may go on between now and then. Shortly thereafter, I discovered that Mr. Kearney had gone on one of his YouTube presentations and encouraged every resident of the town of Canton to file illegal wiretapping complaints against Mr. Albert. Now, I'd be the last person to say that citizens should not contact police departments if they think there's been a violation of the law.
Right, there's nothing wrong with that. Come on.
But one of Mr. Kearney's attorneys, Mr. Betterow, had already sent a letter which I suggest was retaliatory in intent, to the Canton Police
That's
Department,
retaliatory?
claiming
That's
that Mr.
retaliatory.
Kearney was illegally wiretapped. Well, the Canton Police can do with that whatever the Canton Police are going to do with that. I think it would be improper for me as a person charged with prosecuting, as a special prosecutor charged with Mr. Kearney, to even express an opinion to the Canton Police Department. I have my own opinion of the merits of the complaint filed by Mr. Betterow. But that having been filed, Your Honor, what possible purpose does it serve for Mr. Kearney to encourage every citizen of the town of Canton to go and file complaints? And I suggest it serves no purpose
How
but
many
to
did?
harass Mr. Albert.
Or the police department.
I would
They're the ones
also
with the
suggest that it's difficult to look at that video and think anything but that Mr. Kearney clearly saw the video camera, which was visible in the window, and wanted that video recording to be seen and, if possible, heard by Mr. Albert. I think one of the things that may be concluded by the Canton Police, and I don't want to get too far out in front of my skis, is that the illegal wiretapping statute requires that there be secretive video. And when a video camera is clearly visible in front of a store, I would suggest that's not secretive and therefore it's not illegal wiretapping.
Oh, I didn't know
But if
that.
it is, I think when the Canton Police act against Mr. Albert, they can then do a survey of the whole town and possibly bring charges against everyone who has one of those doorbell videos. That said, Your Honor, it was still not my intention to move to revoke Mr. Kearney's bail. But then I became aware just a day or two ago, and I only became aware of this yesterday afternoon, Your Honor. Mr. Kearney, on his show, engaged in about a 10 or 15 minute vile attack on Elizabeth Proctor, describing graphically her giving oral sex to her husband and other such
She's not
comments.
a witness.
Elizabeth Proctor has nothing to do with the Karen Reed case, except that she is the wife of a police officer involved in the investigation and a witness in the case,
Witness or family.
and therefore fair game for Mr. Kearney. And I mention this in particular, Your Honor, because one of the things that I understand the Commonwealth needs to show is that no order entered by the court is likely to be effective in eliminating the threat to the public, or in this case, the threat to witnesses in the Karen Reed case and in the Kearney case, and I would suggest the threat to the fair and objective administration of justice. I think that Mr. Kearney, by his conduct, has amply proved the court he is going to keep going with his intimidating conduct as long as he is free. And therefore, I ask the court to revoke his bail.
Attorney Brady.
Your Honor, Commonwealth uses the word retaliatory. This entire bait and switch the Commonwealth has perpetrated on me and Mr. Kearney is the only thing that's retaliatory here. On Friday, counsel emailed me with respect to the bail issue here today. I said to him that I had, at the time, 2 other cases today. I actually have 3 other cases today. But I don't have time on that date, meaning today, to do what we've been doing here for however long. That if we're going to have a quick bail hearing where the issue is how much money and stay away orders that we've already agreed to in front of Judge Doolin in Superior Court, that's what I expected today. And I've never, in 32 years of practicing law, had a prosecutor or seen another prosecutor when I was a prosecutor say to me, yeah, come on in, we'll get this done quick, everything's going to be fine, and then come into court 5 minutes before coming before Your Honor and say, no, we're going to revoke his bail. Oh, really? Why? Because he said something nasty about somebody. And here's the kicker, Your Honor. In a private show that people have to pay to hear, not in public, to a private audience that somehow got leaked out to whomever. And that show was Thursday night before the Commonwealth committed to a normal bail hearing where there was a very minimal issue at stake. And now the Commonwealth wants to come in here on 5 minutes notice to me and change it up because of this pretextual excuse about something he said that is non-criminal, non-actionable, that he doesn't like in a private setting. That's what's retaliatory, Your Honor.
Well, perhaps I can short circuit all of this.
Please do. Thank you.
Wasn't this addressed in front of the Superior Court? This conduct was addressed?
It was, Your Honor.
So I think under my reading of the bail statute, Mass General Laws, Chapter 276, Section 58B, that the motion to revoke has to be brought at the first appearance in court. It doesn't say which court, his first appearance in court. If he got arrested in Chelsea, this hearing would be happening in Chelsea at the moment of his arrest. And so the idea that this was addressed in front of the court who's hearing the case on which the Commonwealth seeks to revoke, and there were conditions placed as opposed to bail being revoked at that point in time, I think was the first appearance, and I'm procedurally denying the motion to revoke bail because I don't think it's properly before this court.
Thank you, Your Honor. In that case, we would agree under Section 87, Your Honor, to the stay-away orders requested.
What about the cash bail request?
And Judge, in terms of a cash bail, Mr. Kearney's got no record. He's been to every court appearance. We talk, 10 times a week. He has 2 kids, lives in Holden. He's a former school teacher who has shows that he does every single night. I don't know of anybody who has more roots in here that's not going to cause any sort of a flight risk. So I would ask that you forego a cash bail, Your Honor. And he's absolutely willing to just make it a Section 87 agreed on bail condition relative to stay-away orders. And we ask that you allow that.
But if so, we need to
allow
lower.
him to appear on his personal recognizance.
He's thinking. Still thinking. He's writing.
So after hearing on bail, I'm going to release the defendant on personal recognizance with the following conditions. Stay away, no contact, no abuse of the Alberts, remain 100 yards away from the pizza shop and any other workplace, stay 100 yards away from their residences.
He needs to make it a carve out for driving past, or he's going to have to go. I don't know what the roads are like.
With the consent of the defendant.
Correct, Your Honor.
Small town.
We'll answer all you guys' questions when it's over.
May 15th, Your Honor.
That's fine. Oh, wait, was that one of the dates that was not a good date? Okay. May 15th is fine.
So you're going to be released with conditions for your parents back here May 15th for a pretrial hearing. Conditions are that you have no contact directly or indirectly with any of the Alberts and family members, that you remain 100 yards away from the pizza shop and any place of business in the home of the Alberts. Failing to comply with those conditions or picking up any new charges during the pendency of this case, you could be held up to 90 days without bail. That's your bail warning. You'll need to check in with probation. Before you leave the courthouse today, you'll need to sign those conditions of release. Commonwealth's motion to revoke your bail has been denied. The motion to dismiss has been denied. You're all set, sir.
Attorney Bradel, just to be perfectly clear for the record, the defendant consents to these conditions I've checked off under 87 that these are, okay.
Thank you.
All right, thank you.
Thank you.
No, that's all we have.
Court, all right.
All right. So I feel like a real tech wizard that I was able to get that all up for us. And the sound was pretty good. Sound was actually better there than it is in the other courtroom. So,
Hey, so Jody's a new member. What do you got to say?
aw, family hug. Welcome. Welcome to the family.
All right. So introduce our time that we're about to have.
What?
Our
Oh. It's your favorite time. It's my favorite time. It's what does prior restraint? Is that what it was?
No, it's as applied, unconstitutional as applied or on its face time.
Yes. All right. Thank you.
Okay, so a crime, a law, legislation, whatever it is, it can be either unconstitutional on its face, which would be an argument that this can't be applied lawfully to anyone under any circumstances, versus as applied to the facts presented here, which is primarily the argument they were making in this case, that the statute, the witness intimidation harassment statute, is unconstitutional as applied to the specific conduct and speech that is at issue here, because it infringes on his constitutional right, his First Amendment constitutional right. So that being said, initially the argument that the state was making, that there are, it's narrowly tailored, or it can be narrowly tailored and it can be applied, that goes to it on its face. But at issue here was the specific conduct or speech, did that fall into the confines of the lawfully overstep and infringe on his First Amendment right, or was it within the able to be regulated based on the witness intimidation statute? The distinction the judge made here, I guess, is an important one, because his point was, you're not talking about, and the prosecutor made this argument as well, just not as directly, I guess, but you're not dealing with a statute that dictates what you can say to the public as a whole, which would not be allowed, which in this balancing that the court has to do, the public at large, it would outweigh it. But he said, here we're talking about speech and conduct as it is limited to witnesses in a criminal matter. So that's the distinction that he found. Now, also in Illinois, if I illegally record you, because we're a two-party state, so I record sound by you, I cannot use it in a court of law against you. Now, that being said, here, the judge was very specific, and he found, rightly or wrongly, probable cause that the conduct of staring intently into the camera, walking past and coming back, was enough to at least establish probable cause that could be harassing or intimidating. Now, again, right or wrong, that's the basis that he found it on. And maybe it is enough for probable cause, again, probable cause. And it may be unpopular, but I think he found a way to kind of avoid all of the issues at play here, especially the unlawful recording. Now, I'd say that's technically interesting because, I never thought about the fact, because I think that we've had, I'm trying to think if I've had ring camera introduced in order of protection cases, in situations where people were seeking an order of protection. Um, and I'm trying to remember if I had ones that had sound. I didn't make that argument, but that's actually kind of interesting conceptually. That is everyone that's recording sound on their ring camera doing so illegally, but his point that the camera is easily observed, no, that's why there always has to be a sign that says like you are being recorded, or sound is being recorded, because people don't notice a camera necessarily. Um,
And one thing
so
that I want to add, just so people have a clear understanding of procedurally what happened today, so there's the still pending motion to dismiss, which has been argued regarding the 16 other charges. And that was in front of a different judge. That judge heard argument. He is weighing his decisions. He's obviously going to be preparing, some kind of order wherein he's going to make a decision whether or not he's going to dismiss some or all of those charges. This motion to dismiss was filed by Bradel as to the new charge. So that was heard and denied today from the bench. Two separate things. So I don't want people confusing the two, thinking that this related in any way to the argument that we heard a week or two ago, whenever that was, regarding all the other charges. Two separate judges, two different matters completely. So just
I
don't
wonder if
confuse
this
those two.
ruling will have a little bit of, input, like if that might affect this judge's ruling. The way I saw it, I thought that for sure, like there was no question as to some of those charges that they should be dismissed. It wasn't even like a question. Like even like I'm doing here saying, all right, right or wrong, this is what the judge is saying. It's at least enough to go forward. He stared into the camera. He went back. He went forth, and he wanted the guy he wanted someone to view that at some point and be harassed or intimidated, but they did make the point that under the harassment statute, it also requires fighting words or a true threat. So I don't know. He didn't make that argument on intimidation. He did not. I would have liked to see this lawyer throw a little bit more law like that out there when he was like, well, but under the harassing statute, it also defines this conduct like, sorry, X, Y, and Z, in situations where we're not looking at just restricting speech as it relates to the public at large, as opposed to a limited group such as witnesses in a criminal case. Um, so it will be
So
interesting.
Glennon had asked an interesting question in terms of how they're going to define abuse.
So they took
Vers-
that when the judge said it, when he read it out, but then when she recited what his conditions were, they didn't re-say it.
Okay,
They're,
because
they're
that is way too broad of a definition. I
well,
mean,
we do use it all the time when we do stay away or no contact orders that are no abusive or harassing contact.
right.
So, but Bob's right. I mean, it can be vague and overly broad, but
And those are under domestic violence statutes, which are very different than this. This is a witness intimidation statute. So those definitions will most likely be a bit different
well,
in
yeah,
terms
but
of
this
what
was
you're
talking
talking
about
about.
the potential bond condition was where this term.
I get it, but either way, it's a bond condition for a charge stemming from a different statute than a domestic relations statute. This is a witness intimidation statute. So my point being that when you hear the terms of abuses, to what Allison was just talking about in respect to a TRO, or if you're able to come up with some kind of agreement between the parties and get an injunctive order put in place wherein you're going to put just that generic language, no abusive or harassing conduct or contact, like, that you're referring to what would be defined under that statute as abusive. I think it's different in this particular situation because there is First Amendment implications with the fact that Aiden is a reporter, he is a journalist, and he's protected in that sense in terms of his First Amendment rights as to what he could say. Now you're like
Screaming 2
again,
feet
like
from somebody.
you heard Alan Jackson himself saying, the things that he's heard that would have been said and done are vile, some of them, and that may be the case. However, that's what free speech is all about in this country, short of, and in the Commonwealth, they obviously have the fighting words or actual threats.
There
Y-
used to
Yeah.
be, I got to revisit our statutes, but there used to be something where like there's per se kind of harassment, or I don't want to call it defamation, but maybe defamation, where you impugn the integrity of somebody in their profession. That's one. And it used to be something like you impugn the chastity of a woman kind of thing.
Ooh,
I'd have to see if
Scarlet letter. A scarlet letter. You, ma'am, shall wear a scarlet letter upon your bosom.
all right. So tomorrow, obviously, no hearings. So I'm gonna figure it out. The schedule for tomorrow is to be determined. I'll figure
I
out.
haven't thanked Itch yet. Thank you for your generosity. Just sending some love.
And I still want, thank you, Itch. And I still want to, I have not abandoned the Mullis thing. Like, if people think that I have not done it, I'm just
I
trying
feel
to
like you
figure
need
out.
to at this point.
No, I want to watch it. It's fascinating to me. And there's a pending thing that's going to be coming down. An order is going to be coming down with regard to it. So, Mullis, not Mullins, Mullis. It's that post-conviction relief act thing that we watched the first couple days too. I don't think it's an N there, Spit. I think it's Mullis, I believe. I think maybe, yeah. Yeah, I think I'm right. I think his name's Todd Mullis, I think. So yeah, are you saying, Miku, are you saying that we shouldn't get, yeah, we watched the first 2 days of that, Miku. So like I just have to pick it up um on day 3, which I heard was but it only went to the following Monday. So I think maybe tomorrow. I don't know if I'll be able to rope Allie in or not. Like
Or people want it.
I'm not holding my bear.
I've got some in-persons.
I mean, so she might pop in. She might
No, not
grace us
tomorrow.
with oh, she
We'll
gone.
see. No,
So
tomorrow I can.
when do you have in hearings or in
Uh,
persons?
Wednesday, Thursday.
Tomorrow is
And then,
Wednesday, love bug.
oh yeah, tomorrow in the morning. And Thursday. And then we're gone on Friday. So if you need to change something, we've got
Yeah, we might. Unfortunately, one of our dear friends had a death in the family. We've got to take the ride out to Louisville. We got to leave early. So Felonious Friday, unfortunately, is not going to be able to take place. Maybe I'll do something over the weekend just to get it in there. Something. If it depends. I'll kind of look at what's going down, in terms of this week. We've pretty much covered or will have covered everything I think of note, at least in terms of the cases that we are covering. So I'll keep you posted, but there's not going to be anything Friday. Allie and I are going to be on the road, and then we're going to be at a memorial service. So there's no time to fit it in there. So all right, you guys, keep your eyes peeled. I will figure out what I'm going to do tomorrow. I'm leaning heavily towards continuing Mullis, doing it at 1.5 speed, see if we can get through a couple of days there. And that, because I think it's fascinating. We just don't get to see post-conviction relief act trials / hearings like that very often, if ever. I don't know that I've ever seen one streamed. In all fairness, I haven't looked for it. So, but I have a feeling that they're very, very rare. So I think it's worth our time in checking out because that's an interesting case to me. And I didn't follow the trial, but for like a day or two. So I think we'll do that tomorrow. You guys, thank you so much for your continued support financially. We always really, really appreciate that. Venmos and all the supers were
And the
fantastic. Thank
members.
you. All the members, we love you. We love you. We love you. Allie and I have been thinking, I think there's something that I want to do for members. I think I want to actually use both of the puppets, and what my original reason for getting the puppets made was to actually play portions of the Gacy tapes and have the puppets reenacting them. So I'm gonna make you Gacy puppet, and I'll be Daddy Bob puppet. But we'll actually listen to the sound from the Gacy tapes, which, if you don't know, my father was John Wayne Gacy's trial attorney. He gave me all his taped interviews prepping that monster for trial. I'll obviously give trigger warnings before those start because Gacy was the worst of the worst. He is awful. He is like one of the worst human beings to ever grace the planet. I mean, I think Hitler probably hasn't beat out, but it's close. It's close. So I'm thinking about doing that for members only. And I'll give you guys a heads up when we're going to start doing those. We're not going to have like hour-long puppet shows, but we'll do like a 15 minute block of the tapes, because it's a good way, if you haven't listened to our Gacy podcast, which you really, really should, where we do have a lot of the sound from those tapes intertwined with the narrative, the story. If you haven't listened to that, this will be an opportunity to hear what that horrible piece of shit says. And
Right.
it's
Thanks,
super
everybody.
disturbing. So, all right, you guys, we love you. We thank you, because without you, I'm just an old man.
Talking about a lot of cases.